Hello. Hello. Good afternoon, my friends. Good morning, good evening, depending on where you are in the world. Thanks so much for coming to hang out with me today. Today is Thursday, September 12th. And if you were here with me last night, we broke the news that the Karen Reed appeal had been filed, but we did not have a copy of the brief yet. Today we do. So today we're going to go through it. We're going to read it. We're going to look at it together. The actual petition itself is 37 pages. The exhibits are like 316 pages. So we're going to see how much we can get through. I'm so happy that each of you has been able to join me today. Thank you, thank you, thank you. This is kind of a last minute add-on, so I'm going to wait for some people to perhaps get their notifications and join, because so many people are going to be like, I didn't get a notification. And the reason is you have to schedule it with YouTube or StreamYard like more than an hour before it happens for people to get notifications. And that's why I made it 12:05. In case you're wondering why it was a weird time, it's because I had to give it at least an hour to hope that the notifications would go out. So let me know if you got one. And there may be some stragglers, so we're going to give them a minute to come in because of that exact reason. How is everybody on this beautiful sunny day on the East Coast? Are you doing well? Thanks, Christine, for loving the channel and for being a member for 9 months. I appreciate you so very much, each and every one of you who chooses to spend your time with me. I know there's lots of places for you to get your coverage, your Karen Reed coverage, and your trial coverage in general. So I'm so very honored that you have chosen to come and spend it with me. While we're waiting for a couple of people to join or more people to join, hit the like button on your way in, or I'll turn the fan off. I can say that now that we're back to the Karen Reed case. Also, I think while we're waiting for some people to come in, it's a great time to hear a word from our sponsor, because we are so very lucky and fortunate to have a sponsor for this show, because that way we are not beholden to the YouTube sort of censorship rules. So take a listen to my sponsor, Aura, who, in fact, because I use Aura, they notified me that my social security number has been leaked to the dark web and gave me all the tools to be able to protect myself against it. So if you don't know about this major recent hack, your social security number is also on the dark web, and you should really protect yourself. My sponsor, Aura, can help you do that. So let's take a listen. Today's video is sponsored by Aura, and it's a really important time to be talking about them, because hackers may have stolen the social security numbers of every American. Over 2.9 billion records were stolen from National Public Data, which offers personal information to employers, private investigators, staffing agencies, and others doing background checks. These stolen records include a person's full name, address, date of birth, social security number, and phone number, along with alternate names and birth date. And members of this hacker group have reportedly released this information on the dark web for free. I don't know if you've ever had your identity stolen, but I've had clients who've had their identity stolen. And not only is it a major hassle, but oftentimes before you find out, it's too late. The damage can take years to undo, and it's a hassle that you definitely do not want to deal with. So if you haven't been taking precautions before with your personal information online, this should be a huge wake-up call. You've never been more vulnerable online than you are right now. But I'm not too worried about it, because I use Aura. Aura alerts me if they find my phone number, my email, my social security number, or any other personal information on the dark web. They're going to let me know fast if anyone tries to use this information to access my credit or bank accounts. They give me up to $5 million in identity theft insurance should the worst case scenario happen. They also provide a bunch of other features to keep you safe online, all inside one app. And you can go to my link at www.aura.com/Melanie Little to try it for free for 14 days. That'll be enough time for Aura to find out if any of your personal information or data has been exposed. I highly recommend you do this right now, because Not only is national public data not going to do anything to help you, they probably aren't even going to face any repercussions for this breach. I'm not leaving myself and my family vulnerable to data breaches. And if you don't want to either, you want to go to my link, www.aura.com/Melanie Little, to try 2 weeks for free. You can thank me later. You can thank me later because they actually did notify me. And Jules just said that, where's that comment, Jules? You got a notification from Medicare that they were hacked in June and July and your info was part of it. Yeah. Well, this one, National Data Company or whatever, National Data Breach Company, every single American's social security number is out there. And if you've ever had your credit ruined because your identity was stolen, it is something that could take like 10 years to fix. You don't want to have to deal with that, and I'm here to help. All right, my friends, let's get to it. Let's do it. We are going to read the petition for relief, and if there are some exhibits that we want to look at while we're going through it, we're going to switch back and forth to the appendix. The appendix is where all of the exhibits are. And it is very, very difficult for me to read the chat while I'm reading to you. So please know that it is not for lack of me trying to see your comments, but I absolutely cannot see them while the chat is flying by and I am reading to you. The super chats go into a separate column. Somebody was complaining last night. There's always something to complain about, right? Do you only read comments from members? Because I don't know. That's not true. I give everyone a fair shot on this channel. If you've been following me, you know that I read everyone's comments. It doesn't matter what your status is, but just know that when chat's flying by and we've got 3,000, 4,000 people in here at a time, it's virtually impossible for me to see your comments fly by. So do not feel offended. Do not take it personally. Thank you so much for Mama She for coming in with the 10. Happy Friday Eve. Where are you, Mama She? Love being here with all the cupcakes. Thank you so much for your very generous donation. Cookie Harris, thanks for the 20. So happy to catch a live after a busy few months. My favorite channel and community. Love and hugs to you, Melanie. Love and hugs to you right back, Cookie. Thanks, Cookie. Thank you later. Thank you, David, for always coming in, and Christine for loving me. And I love all of you. All right, here we go. This is the petition for relief pursuant to General Law GL Section 211, Section 3, filed by the attorneys for the defense, Karen Reed versus Commonwealth of Massachusetts. The attorneys listed on the brief: Martin Weinberg, Michael Pabian, Alan Jackson, and David Yannetti. People are saying, why isn't Elizabeth Little on the brief? Is she not on the team anymore? It means nothing. It means nothing. It means she's not on the writing of the brief. She may not be admitted. They may not want her admitted pro hoc vice for purposes of the appellate court arguments. It does not mean in any way, shape, or form that she is no longer part of the team. So do not get in a bunch about that. Here's the table of contents. Appellate brief writing, as I've explained to you before, is a very special skill, and there are special rules that need to be followed. There are special printers that you need to use. And when I mean printer, I mean like a printing service. You can't just print it up from your home printer. They have to be bound and gagged. No, not gagged, but they have to be bound, and they have to be a certain color, and they have to be a certain type font, and they have to be a certain size font. And it's a special skill, and it costs a ton of money to do appellate printing or to pay for appellate printing. And many, many firms hire out appellate attorneys just to write their briefs because it is such a special skill. Not only do you need to be good at oral argument, but you need to be good at brief writing. And we move on. If you're just tuning in, good morning, good evening, good afternoon, good night. You haven't missed a thing. This is page 1 of the appellate brief, the petition. Now comes the defendant, Karen Reed, who was aggrieved by an August 23rd, 2024 memorandum of decision and order. Here in order, denying her motion to dismiss on double jeopardy grounds in the Commonwealth versus Karen Reed, number 22-00117, Norfolk County Superior Court. Honorable Beverly J. Cannoni presiding. The order as it currently stands will result in Ms. Reed being retried on January 27th, 2025 for the same 2 alleged crimes, including second-degree murder, that a jury of her peers has already unanimously agreed the Commonwealth failed to prove beyond a reasonable doubt following trial. Because the jury reached a final unanimous decision to acquit Ms. Reed on those charges, and because there was no manifest necessity supporting the declaration of a mistrial with respect to charges on which the jury unanimously agreed, retrial on such counts would violate the double jeopardy protection of both the federal and state constitutions and the common law decisions of this court enforcing the protections of double jeopardy. I'm going to break for a second to tell you this is my cursor on your screen. Please do not break your television thinking it's a fly and send me the bill. I have to put the cursor there because it's the only way I can scroll through it. Ms. Reed seeks relief from this court through its discretionary superintendent's powers under GL Section 211, Section 3. In support of this petition, the defense has submitted a memorandum of law incorporated herein and has attached a record including the following documents. And that is the 316-page appendix that I have pointed out to you. A full docket report, which is the first 44 pages. The Norfolk County Superior Court indictments, which is the next 5 pages. Transcript of the charge to the jury. We've talked about this at length, about how Judge Cannoni's jury instructions were so confusing. And that goes from page 51 to page 113. Transcript of the jury trial. Well, it's certainly not the entire jury trial, but this is pages 114 to 136. Defendant's motion to amend the jury verdict slip associated with count 2 and supporting affidavit, which was filed June 26, 2024, encompasses pages 137 to 45. Transcript of trial, and this is another small excerpt of the trial transcript, pages 146 to 52. Another portion of the trial transcript, 153 to 63. Another portion from 164 to 77. Defendant's motion to dismiss and supporting affidavits filed July 8th, 2024. That goes from page 178 to 194. Defendant's supplemental memorandum in support of her motion to dismiss and supporting affidavit filed July 10th of 2024. That's 5 pages. Commonwealth's opposition to defendant's post-trial motion to dismiss filed July 12th, 2024. It's about 14 pages. Defendant's reply to the Commonwealth's opposition to her motion to dismiss filed July 15th, 2024, and that is about 10 pages. Defendant's second supplemental memorandum in support of her motion to dismiss and supporting affidavit filed July 18th. That is approximately 4 pages. Commonwealth's post-trial notice of disclosure filed August 1st of 2024. That is 2 pages. Defendant's third supplemental memorandum in support of her motion to dismiss and supporting affidavit filed August 5th of 2024. That's about 4 pages. Transcript of non-evidentiary hearing on the motion to dismiss, August 9th, 2024. And that's about almost 50 pages. Memorandum of decision and order on defendant's motion to dismiss issued August 23rd of 2024. Under General Law, Section 211, Section 3, or Subsection 3, the Supreme Judicial Court has general superintendence of all courts of inferior jurisdiction to correct and prevent errors and abuses therein if no other remedy is expressly provided, and it may issue all writs and processes to such courts which may be necessary to the furtherance of justice and to the regular execution of the laws. Quote, a criminal defendant who raises a double jeopardy claim of substantial merit is entitled to a review of the claim before she is retried. And General Law, Section 211, Sub 3 is the appropriate route for obtaining that review. Citing PAP v. Commonwealth. Because the double jeopardy right is a right not to be tried, this court has held that appellate review of the denial of a motion to dismiss on that basis after trial and conviction would not provide adequate relief if the defendant were to prevail. Flood v. Commonwealth. See also Abney v. United States. The rights conferred on a criminal accused by the Double Jeopardy Clause would be significantly undermined if appellate review of double jeopardy claims were postponed until after conviction and sentence. This court has long recognized that the Double Jeopardy Clause protects an individual against more than being subjected to double punishments. It is a guarantee against being twice put to trial for the same offense. Request for oral argument. Ms. Reed respectfully requests that the court hold oral argument on this petition. Introduction. The ancient right to a jury trial is no mere procedural formality, but rather a fundamental reservation of power to the American people. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions. Prominent among the reasons colonists decided in the Declaration of Independence for their break with Great Britain was the fact that Parliament and the Crown had deprived them in many cases of the benefits of trial by jury. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. See Commonwealth v. Taylor, which says, perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. The Double Jeopardy Clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb, citing Bluford v. Arkansas, which is a U.S. Supreme Court case from 2012. The underlying idea, one that isn't deeply ingrained in at least the Anglo-American system of jurisprudence, is that the state, with all its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense, citing Green v. United States, a 1957 case. Even if the first trial is not completed, a second prosecution may be grossly unfair. It increases the financial and emotional burden on the accused, prolongs the period in which she is stigmatized by an unresolved accusation of wrongdoing, and may even enhance the risk that an innocent defendant may be convicted. Consequently, as a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. Citing Martin v. Lennon, which says, at the heart of this policy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression. Bluford, which says, the clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. Starting off strong, in my opinion, because what have we talked about many, 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 many times ad nauseum? How much money this is costing Karen Reed to defend against. And what would the harm be in calling the jurors back and asking them a simple question without going into their inner workings, the inner workings of the jury, without asking them what their deliberations were about or how they came to their determination or what people said in the jury room? Did you acquit on count 1 and count 3? Yes or no? It's simple. But Judge Cannoni didn't want to do that. That said, she has been overturned before in the SJC. So there's that. Let's go to the chat for a sec. Sons 107, so happy that you're here. Thanks for being a member for 6 months. Thank you, Danielle, for gifting a membership, and Chantal for gifting a membership. And to whoever received those randomly by YouTube, congratulations and welcome. Here, the very day after the trial court declared a mistrial, counsel for Ms. Reed began receiving unsolicited communications from 5 of the 12 deliberating jurors, in 4 instances directly from the jurors themselves, indicating in no uncertain terms that the jury had a firm and unwavering 12-0 agreement that Ms. Reed is not guilty of 2 of the 3 charges against her, including the charge of murder in the 2nd degree. Crucially, neither the Commonwealth, which frankly acknowledged receiving communications from 1 juror to the same effect, nor the Superior Court judge, who expressly credited the veracity of juror statements relayed in affidavits by counsel, disputed the factual basis for the defense motion in any meaningful respect. Given the central importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes prosecution of Ms. Reed on counts 1 and 3 and mandates dismissal of those charges. This presents an issue of first impression for this court, as does the defense's alternative contention that Ms. Reed was entitled to a post-verdict inquiry to substantiate her claim, and that this court's precedents permitting such inquiry regarding claims of racial bias should be extended to the present context. I'm going to break for a second to say exactly what I've been saying all along. There is no case law on this issue in Massachusetts because it's never been litigated before. That's what they mean when they say this is a case of first impression. It's never happened before in this exact way. Therefore, the defense is arguing it's time for the appellate court to make some law here, to change the case law, to extend post-verdict inquiry to a case such as this. Independently, while a jury deadlock constitutes manifest necessity to support a mistrial, there's no authority for the proposition that disagreement as to some counts constitutes manifest necessity for the declaration of a mistrial with respects to all counts. Put another way, there was no deadlock as to 2 of the counts on which the trial court declared a mistrial. The trial court's finding that Ms. Reed's counsel consented to the mistrial is contrary to both the factual record and the clear binding case law, placing the burden of establishing manifest necessity solely and exclusively on the prosecution. The trial court also failed to address the 2 guiding principles set forth in by this court in Taylor, that before a mistrial is declared, counsel must have been given full opportunity to be heard, and 2, the trial judge must have given careful considerations to alternatives to a mistrial. Thus, whether the jury acquitted Ms. Reed or alternatively was merely not deadlocked on the relevant counts, the Constitution requires the same result: dismissal. The Commonwealth's response on this issue, arguing that inquiry regarding partial verdicts should be prohibited under case law involving lesser included offenses within a single count, unlike the present case, raises an important issue regarding the interaction between that lesser included offense, case law, and Massachusetts Rule of Criminal Procedure 27B, which plainly permits and in fact requires the court, before declaring a mistrial, to inquire of a jury where there exist partial verdicts where multiple offenses are charged in separate counts. Thank you, Donnie Not Wahlberg, for gifting a membership. I appreciate you so very much, and I appreciate your name so very much as well, your screen name. Procedural history. On June 9th of 2022, Ms. Reed was charged in 3 separate indictments with second-degree murder in violation of General Law 265, subsection 1, count 1. manslaughter while operating under the influence of alcohol in violation of these laws, and leaving the scene of a collision resulting in death in violation of another law. A jury trial began. All right, I think I left out the first one. Hold on, I'm going to start that again. On June 9th of 2022, Ms. Reed was charged in 3 separate indictments with second-degree murder in violation of GL section, did I say that one? Second-degree murder was count 1. Manslaughter while operating under the influence of alcohol was count 2. And leaving the scene of a collision resulting in death, which was count 3. That was confusing because they put the counts after the charge and they don't ever say count 3. Okay, anyway. A jury trial began on April 16th of 2024, and that is in the record starting on page 45. Let me see if we need to look at that. Let's take a look at the original indictment. I'm going to just flip screens for a second. And here's the original indictment handed down. And this is the second one. Remember, she was first arrested and arraigned. Well, I guess this is the first indictment, but she was originally arraigned not on murder charges, but manslaughter charges. And that was in February of 2022. This was in June of 2022. After a grand jury heard the case, Karen Reed of Mansfield in the county of Bristol on or about January 29th of 2022 at Canton in the county of Norfolk did assault and beat John O'Keefe with intent to murder such person, and by such assault and battery did kill and murder the said John O'Keefe, and is guilty of murder in the second degree and not in the first degree in violation of Massachusetts General Law, Section 265. I don't know why it's worded this way. This is very ancient language, but the assumption is she assaulted and beat him with her car. I know it's confusing. Welcome to Massachusetts. And that was a true bill signed by the district attorney for second degree murder, June 9th, 2022, signed by the clerk. And this was the second charge that they were indicted. The grand jury indicted was Karen Reed did operate a motor vehicle upon a way as defined in Massachusetts general law, or in a place to which the public have a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, with a percentage by weight of alcohol in her blood of 8/100ths or greater, or while under the influence of intoxicating liquor, and did so operate said motor vehicle so that the life and safety of the public might be endangered, and by such wanton and reckless conduct so described, did cause the death of another person, to wit, John O'Keefe. True bill was signed by the foreman of the grand jury, foreperson. And then the third count, which was leaving the scene of an accident causing personal injury or death in an attempt to avoid prosecution or evade apprehension after knowingly colliding with or otherwise causing injury to John O'Keefe. After hearing some of those juror interviews, now I can understand why they acquitted on count 3, which is this count, because many of them felt, or all of them felt, that Karen did not knowingly collide with John. In my opinion, she did not collide with John at all, but I'm not on the jury. But I'm still flummoxed by the whole thing. Back to the brief. The jury trial began on April 16th of 2024. On June 25th of 2024, the jury began deliberations after receiving instructions from the trial court. The trial court instructed the jurors, you should continue deliberating until you have reached a final verdict on each charge. Remember, we played that over and over and over again. But it's attached here as an exhibit. So we're just going to read it. We're not going to watch it. This is a transcript of Judge Cannoni's charge to the jury because we like receipts. And they come with receipts in these documents because that's what an appeal is all about. You have to include all of the receipts. Otherwise, you got nothing. And here it is. These are the words of Judge Beverly Cannoni, and I'm going to read them to you. You should continue deliberating until you have reached a final verdict on each charge. You should not begin deliberating until all 12 jurors are together in the jury room and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I instruct you that no juror is better qualified to determine the truth of the facts in dispute or to deliberate on a verdict solely because of education, background, or experience. Well, that's interesting because didn't one of the jurors tell Aiden Carney that they thought that the foreman was smarter than everyone else and that he was in charge and he made the rules? The parties and I have chosen each of you as a fair and impartial jurors, and your voices have equal weight. To reach a unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartially considering the evidence with his or her fellow jurors. And here's what they're pointing out in this part of the brief. You should continue deliberating until you have reached a final verdict on each charge. It's right there for all to see. It also noted that count 2 contained lesser included charges of involuntary manslaughter and motor vehicle homicide, which the jury should consider even if the Commonwealth failed to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. Let's see if there's anything in here to help us with that. Say 85. This is again the transcript of Judge Cannoni's jury instructions. The Commonwealth may prove the lesser included charge of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. And they're saying that she said it twice on 85 and 88. Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. There's your receipt right there. The following day, on June 26, 2024, outside the presence of the jury, counsel for Ms. Reed raised an issue regarding the verdict form. With respect to count 2, the original verdict slip provided only one option to find Ms. Reed not guilty before going on to ask whether Ms. Reed was guilty of the offense charged or guilty of one of the lesser 2 included offenses. See Exhibit B to affidavit in support to amend the jury verdict slip, which is the record, page 145. See how nicely they do everything in the appellate court? Everything is nicely numbered and collated and easy to find. Here's the verdict slip as it originally read. We went over this at length as well, but it's a little refresher. This is the verdict slip for only offense number 2, which was manslaughter while operating a motor vehicle under the influence. Oops. In the above entitled case, we, the jury, say that the defendant is 1, not guilty, 2, guilty of offense as charged, and then it's got manslaughter while operating a motor vehicle under the influence, and then it says, check one or both of the following: manslaughter while operating a motor vehicle under the influence of alcohol and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.8 or greater. Number 3, guilty of lesser included offense, involuntary manslaughter. Then number 4, guilty of lesser included charge of motor vehicle homicide, felony OUI, liquor, and negligence. And then it says, check one or both of the following: motor vehicle homicide by operating a motor vehicle under the influence of alcohol and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08% or greater. Tell me how in any world 12 people could ever agree on how to fill this slip out. Okay, I've been an attorney for 30 years, a litigator in New York, and this is confusing to me. How do they expect a layperson to even know where to start with this thing? I don't know. Hence, we appeal. And I will repeat what I just read. With respect to count 2, the original verdict slip provided only one option to find Ms. Reed not guilty before going on to ask whether Ms. Reed was guilty of the offense charged or guilty of one of the 2 lesser included offenses. Counsel asked that the form be amended to provide not guilty options for the subordinate charges under count 2. The trial court initially indicated its disagreement with counsel's request. However, after considering the matter further, the court agreed to provide supplemental instructions and an amended verdict slip. Later that day, the court provided the supplemental instructions, telling jurors that count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a vehicle under the influence of liquor. The jury should first focus on that lead charge, and if the Commonwealth failed to provide that crime beyond a reasonable doubt, then consider the remaining lesser included offenses in descending order. All of the receipts for everything in this paragraph are attached in the exhibits. I just want to see the argument. This was 118 in the record. Give me a second. Yeah, here we go. All right, we're going to see a transcript now of when AJ smooth as butter. Let me see some smooth as butter emojis in the chat, members. had a little something to say to the judge. Court resumed at 10:02 a.m. The jury was not present, but the defendant was present. The clerk, 22117. The court, when it says the court, it means the judge. So why are we out here? Mr. Jackson, Your Honor, I just saw the verdict forms. And as we discussed yesterday, the amendments that the court indicated it would make on the verdict forms have not been made. The court. Oh, no. Okay, I did not say I'd make it. I said I would think about it. I said I was tired and I needed to think about it. Mr. Jackson, well, what you said before, you were tired and you needed to think about it, was you agreed that there needs to be not guilty options for the subordinate charges under count 2. The court. I said that it made sense to me. But no, I did not change it upon looking at it because this verdict slip, as submitted to the jury, is exactly how it always is in Massachusetts. Mr. Jackson, well, can I ask you a question then? I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate. The court, it's appropriate. Mr. Jackson, those are two different things. The court, it's appropriate. Mr. Jackson, let me make my argument, if you wouldn't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge, and that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's 2 additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter? The court. Anything else you want to say, Mr. Jackson? Mr. Jackson, I'd like an answer from the court. How do they decide that she's, that's a typo. That's a typo. It should say, how do they decide that she's not guilty of involuntary manslaughter on that verdict form? And this transcript says that she's too guilty, T-O guilty. That's the court reporter's error, because in Massachusetts, she's speaking into that athletic supporter instead of typing on an old, court reporting steno machine. The court, that's their decision to make, Mr. Jackson. And how do they make it if they don't have an option to check a box that says not guilty? They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty. And on the top, you're left with not guilty, okay? Mr. Jackson, so it's the absence of the check mark that the court determines is the not guilty finding by the jury? The court, yes. That's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty, okay? Mr. Jackson, that's how it is, Mr. Jackson. Mr. Jackson, well, apparently that's how it's going to be because the court's ordered it, but that's not how it should be. And it's over our strong objection. They need to see that there's a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charge. The court, I disagree with you. Mr. Giannetti. Oh, wait, let me do that again. The court, I disagree with you. Ms. Giannetti, you've seen verdict slips exactly like this? Mr. Giannetti, I actually haven't, Your Honor. The court, you've had no lesser includeds? Mr. Giannetti, no, we've always had lesser includeds, but I've not seen a verdict slip there where not guilty is not an option for a lesser included. The court, I disagree. Mr. Jackson, and I don't see the, excuse me? This is funny, Ms. Reed. All right, we're done. How clearly do we remember that exchange? Pretty clearly, but when you see it in script form, because that's what a transcript is, it comes back like you're reading a play. Somehow it hits differently. Thanks, Cat B, for calling me your favorite law tuber to go down the Karen Reed rabbit hole with. And thank you, Catastrophe, for your super sticker as well. You guys are awesome. Susan, thanks for becoming a member. All right, back to the document. On June 28th, 2024, the jury sent the following note to the court. I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. June 28th, 2024, transcript at 1:56. The court asked counsel for their views on whether there had been due and thorough deliberations sufficient to support the giving of a so-called Tui Rodriguez charge. See also General Law 234A, subsection 68C, permitting the charge if a jury, after due and thorough deliberation, returns to court without having agreed on a verdict. The Commonwealth responded that the charge should not be given because there simply hadn't been sufficient time yet. Counsel for Ms. Reed disagreed, requesting that the court read the Tui Rodriguez model instruction and go from there. The trial court sided with the Commonwealth, ruling, I am not prepared to find that there have been due and thorough deliberations at this point, so I'm going to send them back out. All right, I want to see if they show the actual note or it's just a transcript of the note. Give me a second here. Because I'm really curious to see, the handwriting and stuff on that note. What is the 156? It's just a transcript. Okay, we don't need to read that. On July 1st of 2024, the jury presented another note stating, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implication it holds. That's also in the transcript. Upon being asked by the court, the parties reiterated their same previously expressed views, with the Commonwealth taking the position that due and thorough deliberations had not yet occurred, and Ms. Reed's counsel arguing that the court should give a Tui Rodriguez instruction. This time, the trial court decided to give the requested instruction. Later that day, the jury sent yet another note. Therefore, without reading the note to counsel, thereafter, without reading the note to counsel and without providing counsel with either an opportunity to be heard or an opportunity to consult with their client about the implication of a potential mistrial on one or more charges, the trial court simply stated, the jury is at an impasse, and called in the jurors. It then read the note on the record. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. After reading the note and without soliciting the views of counsel in any respect, the trial court stated, I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. The jury was then excused and ordered to leave the courtroom. Counsel was not invited to speak during this entire interaction. Receipts attached. The following day, on July 2nd, 2024, unsolicited by any party, one of the jurors, Juror A, contacted one of the attorneys for Ms. Reed, Alan Jackson. Juror A stated that he or she wished to inform Attorney Jackson of the true results of the jury's deliberations. That's included in the affidavit of Alan Jackson. We went over those motions at length, so I'm not going to read them again here. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic that count 1, second-degree murder was off the table and that all 12 of the jurors were in agreement that she was not guilty of such crime. The jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury or death. One day later, on July 3rd, 2024, another attorney for Ms. Reed, David Yannetti, was contacted by two different individuals, hereinafter Informant B and Informant C, who had received information from two distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in this case, citing the affidavit of David Yannetti. Informant B sent attorney Yannetti a screenshot he or she had received from someone, hereinafter intermediary B, of text messages that intermediary B had received from Juror B. In that screenshot, Juror B texted the following to intermediary B. It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. And that's as it was written. Juror B later placed an unsolicited call to attorney Yannetti, confirming that the information contained in the publicly filed affidavit was accurate. See supplemental affidavit of David Yannetti. Juror B clarified, however, that he or she meant to write, no one thought she hit him on purpose or even knew that she had hit him. Juror B further told attorney Yannetti that he or she believed that every member of the jury, if asked, would confirm that the jury reached not guilty verdicts on indictments 1 and 3. Informant C had been in contact with another individual, intermediary C, who was a coworker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. Informant C sent attorney Yannetti the below screenshots of his or her text messages with intermediary C regarding what Juror C revealed in the Zoom meeting. Intermediary C, no consideration for murder 2. Manslaughter started polling at 6-6, then ended deadlocked at 4 no, 8 yes. Informant C, interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip that was all confusing. Intermediary C, she should have been acquitted, I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. Ms. Reed moved to dismiss counts 1 and 3 on double jeopardy grounds, contending 1, that the jury reached a final unanimous decision to acquit her on those charges, and 2, that there was no manifest necessity supporting the mistrial, given the evidence that the jury was not deadlocked, but was instead in agreement on those counts. In the ensuing days after the filing of Ms. Reed's initial motion to dismiss, but before the Superior Court hearing on that motion, Attorney Jackson was contacted by two other deliberating jurors. The first, Juror D, stated that the jury reached not guilty verdicts on counts 1 and count 3, and that the disagreement was solely as to count 2 and its lesser offenses. Supplemental affidavit of Alan Jackson. She or he recounted that after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on count 1 and 3? Juror D unequivocally told counsel, every one of us will agree and acknowledge that we found Karen Reed not guilty of counts 1 and 3 because that's what happened. Juror E similarly stated that the jury was unanimous on 1 and 3, that Karen Reed was not guilty of those charges. And that's in the second supplemental affidavit of Alan Jackson. The Commonwealth filed a post-trial notice of disclosure informing the court that on Sunday, July 21, 2024, Assistant District Attorney Adam Lally received an unsolicited voicemail on his office's phone line from an individual who identified themselves as a juror by full name and seat number. The message stated, it is true what has come out recently about the jury being unanimous on charges 1 and 3. ADA Lally received a subsequent message from the same individual stating that he could confirm unanimous on charges 1 and 3 as not guilty, and as of last vote, 9-3 guilty on the manslaughter charges. The Commonwealth additionally received emails from 3 individuals who identified themselves as jurors and indicated that they wished to speak anonymously. The Commonwealth declined to substantively respond to the voice message or emails, instead claiming in responsive emails that it was ethically prohibited from discussing such matters. After hearing oral argument on August 9th, 2024, on August 23rd, the trial court issued an order denying Ms. Reed's motion to dismiss. Note that it took her 14 days to render that decision, as opposed to some of the motions in pretrial that took more than 70 days. 70. The court accepted for the purposes of the motion to dismiss that the juror statements quoted in the defense affidavits were true and accurate. It went on, however, to hold that because there was no open and public verdict affirmed in open court rendered in this case, the defendant was not acquitted of any of the charges. The court similarly rejected the defense argument regarding lack of manifest necessity, finding that A, Ms. Reed's counsel consented to a mistrial via their failure to object, and B, the jury notes reflecting an impasse established the requisite manifest necessity. The court did not address the Taylor test for declaring a mistrial based on manifest necessity, nor did it address Ms. Reed's contention that the burden of demonstrating manifest necessity is squarely on the prosecutor. The court instead erroneously equated a request for a Tui Rodriguez instruction, which is designed to encourage a verdict, with consent to a mistrial. Finally, the court rejected the defense's alternative request for a post-trial inquiry on these issues on the grounds that the request implicated the substance of the jury's deliberations. We also went over that order at length, which you can find in a prior stream in the Karen Reed post-trial playlist on my channel. Ms. Reed's retrial is currently scheduled to begin on January 27th of 2025. And here's where we begin the memorandum of law. So let's go to the chat. See if we have any questions. Oh, Amanda, so glad that you're here with me today as well. She says I'm her favorite. Hashtag free Karen Reed. Thanks, Amanda. Chloe Albert's Revenge. Thanks for the 5. Bev disagreed with them about the form, but agreed with Lally that a crash test dummy and a crash expert are the same thing. Exactly. You got to look at the source, Chloe Albert's Revenge. Thanks for the 5. Kelly, could this blow up in Judge Bev's face going to SJC? Well, I mean, the only thing that happened is she could be overturned and it would get sent back to her. I don't know what you mean by blowing up in her face, but judges don't like to be overturned. And this has already happened to her once in the Karen Reed case during the pretrial. So it's not like she gets, fined or penalized or anything, but judges do not like to be overturned. Elf, thanks for being a member for 8 months. Been hooked since the beginning of this case. Thank you, Elf. Thank you, Elf, for gifting a membership. Susan Costello, thank you for coming in and gifting 10 memberships. Wow, we have a lot of new members today. A lot of new cupcakes. Thank you so much, Susan, for your kind and generous gift, as always. Danielle is obsessed with this channel. I may need help. I mean, at least it's a healthy obsession, right? Thank you, Danielle Alexander. And you are such a very important part of this community as well. Michael, great question. Why do so many courts not want to set new precedent, new law, when it is the first time something comes up? Because the trial court judge, which is usually the lowest judge, wants the appellate judges to make that decision. Many of them are afraid. You are correct. I don't know. If I was a judge, I think I would just do it all the time. Go with my gut. But that's me. And that's why I'm not a judge. That is why, yeah. JB Eagles is like, maybe they should do a better job if they don't like to be overturned. Either way, she ruled it would have been appealed, right? And she said that when she set the trial date for end of January. She said, I know this is going to go to appeal no matter what. So that's why she took 14 days to decide. And then here we are. Wonder 5. Judges don't like to be overturned, but also judges don't like to overturn judges, are hesitant to do so. Maybe sometimes, but I don't know. I don't know what's going to happen here. I want to see the response, and I haven't read all the case law, so it's hard for me to give you like a fully baked opinion on this right now as we are reading this together. We will see. Scott's the chocolate. What are you talking about, Scott? What's the point of an appeal? An appeal is so that the appellate court can decide who's right and who's wrong under the law of the state of Massachusetts. And if they want to extend the law, because this exact issue has never been litigated before, they have the power to do that. That's how case law is made. Oh, you're welcome, Junebug. You're welcome. No, you're the best. No, you are. No, you are. Okay. Here's the memorandum of law. Got to make this a little more interesting, right? Point 1, the jury's unanimous conclusion following trial that Ms. Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes reprosecution. What constitutes an acquittal is not to be controlled by the form of the action in question. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offense charged. The mere presence or absence of check marks on a form is not dispositive. Quoting Taylor. Here, the affidavits by Attorney Jackson and Yannetti reflect statements by 5 deliberating jurors that the jury had reached a final unanimous conclusion that Ms. Reed is not guilty of counts 1 and 3. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the results of the jury's deliberations. Juror A was emphatic that count 1, second-degree murder, was off the table and that all 12 of the jurors were in agreement that she was not guilty of such crime. Another juror B said it was guilty. Juror B said it was not guilty on second degree. No one thought she hit him on purpose or even knew that she had hit him. Reflecting Juror C's statement relayed by intermediary C that there was no consideration for murder 2 and Ms. Reed should have been acquitted on that count. Juror D, without hesitation, said in substance, every one of us will agree and acknowledge that we found Karen Reed not guilty of counts 1 and 3 because that's what happened. Juror E explained that the jury was unanimous on 1 and 3 and that Karen Reed was not guilty on those charges. As noted above, the trial court accepted the foregoing averments as true facts. And she said that in her order. She was accepting all of those statements as true for purposes of her ruling. And then it was fakakta. In rejecting Ms. Reed's claim of acquittal, the court relied solely upon the lack of an open and public verdict affirmed in open court. This reasoning is rooted in a formalism that has been consistently rejected by the U.S. Supreme Court and Supreme Judicial Court in a string of precedents spanning more than 100 years. The Ball case says, however, it may be in England and this country a verdict of acquittal, although not followed by any judgment, is a bar to a subsequent prosecution for the same offense. Hudson v. Louisiana holds that judicial grant of a new trial prohibited retrial on double jeopardy grounds, notwithstanding that the state code of criminal procedure did not authorize the trial judges to enter judgment of acquittal in jury trials. Where is this footnote? Oh, number 1, hang on. Okay, I missed the footnote. Going back to the top of the page, as noted above, the trial court accepted the foregoing averments as true facts. And then there's footnote number 1, which says, just days ago, An article was published online reflecting an interview with an anonymous juror quoted as saying, quote, "It was very clear on charge 1 and 3. Murder was decided on day 1. She did not have an intent to murder." Citing Aidan Carney, Canton Cover-Up, Part 397. Karen Reed, juror, says they switched on manslaughter verdict. Confirms murder acquittal. Says jurors couldn't ask Judge Cannoni questions about 2 verdicts. Published September 6th of 2024. Available at, and then they provide the link to Turtle Boy's website. Aidan, I don't know if you're watching, but if you've never been cited in anybody's court papers before, know that you are now contained within the appellate record of the Karen Reed case as an official citation. So to whoever calls you not a journalist, just refer them to this, page 14 of the brief. Well done, sir. Well done. Indeed, under the trial court's reasoning, affidavits executed by all 12 jurors attesting to a final unanimous decision to acquit would not be sufficient to mount a successful double jeopardy challenge. Surely that cannot be the law. Indeed, it must not be the law. And in the context of this highly publicized case, it strains credulity. It strains credulity. I have merch. I've had merch since way before the Karen Reed case that says it strains credulity because I love that phrase. Oh, now you got to go. Everybody's got to go buy it strains credulity mug, sweatshirt, t-shirt, something. It's all there. There it is. It's already made. Look for discount codes too if you go to my spread shop, because a lot of times they have discount codes at the top. Hold on a second. I got so excited. I lost my place. Look. It strains credulity. It's right here. I think the judge also used that in her order, didn't she? It strains credulity to suggest that if the unequivocal statements of 5 jurors quoted above did not, in fact, represent the unanimous view of all 12 remaining jurors, if you're in South Carolina, that's how I say, jurors, would allow the inaccuracy to go uncorrected. Instead, they would predictably have notified the Commonwealth or the court of their own recollection. Here, to the contrary, au contraire, the Commonwealth has received the exact same information as the defense regarding the jury's unanimous agreement to acquit Ms. Reed on counts 1 and 3. I'm going to break to say, I wonder if they're going to point out that Adam Lally epically failed to admit or to even state when those emails were received by the Commonwealth from those jurors. Chantal, so funny. Au contraire, mon frère. Oh, he did? He pointed out it was my phrase. Woot, woot. Look at both of us kind of were given like a little, well, he was given an absolute nod as being a credible news source. Maybe that was like a little wink to me. I don't know. Probably not. But, you know, a girl can dream, can't she? All right, moving on. Whew. Very exciting. The United States Supreme Court's decision in Bluford is not to the contrary, as it is factually distinguishable from the instant case. There, the foreperson had reported during the deliberations that the jury was unanimous against the charges of capital murder and first-degree murder, but split on manslaughter. The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited reprosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality of the juror's report. The jury's deliberations had not yet concluded, and it went back to the jury room to deliberate further. And that, my friends, is how Bluford is distinguished from this case, because the jury was sent back to deliberate. Here, the jurors are saying, we were done deliberating. She declared a mistrial without asking us whether we were unanimous on any of the charges, because clearly, as shown in that earlier receipt, she said, do not fill out the slips until you've reached a unanimous verdict on all counts. That's how Bluford is distinguished, my friends. The four persons report was not a final resolution of anything, and there was no indication at the conclusion of deliberations that it was still the case that all 12 jurors believed the defendant was not guilty of capital or first-degree murder. Here, by contrast, the jurors' statements reflect a final and indelible determination that persisted through the end of deliberations and following. I'm going to break from the document to say yes, and following, to the point where they were so upset about it that 5 of the 12 reached out to defense counsel, and at least 4 of the 12 reached out to the Commonwealth. That is a little more than 1/3 of the deliberating jurors. The contrast with a juvenile v. Commonwealth is even clearer. In that case, after the conclusion of trial, a court officer found 4 verdict slips in the deliberation room, two of which reflected entries of not guilty. There was no indication as to when the entries were made or in what circumstances, much less that they reflected a final unanimous conclusion of all jurors. In that case, a juvenile is from 1984. The Bluford case, well, I have to scroll too far back to find out what year that was. Neither the Commonwealth nor the trial court has cited any case in which a defendant was forced to stand trial a second time for an offense a previous jury had found her not guilty, simply because such final unanimous agreement was not announced in open court. See the August 9th transcript. Counsel arguing that Commonwealth had not cited a single case with facts like this that have been ignored. Not a single precedent have they raised nationwide. State courts, murder cases, 50 states, federal, where there's been this kind of demonstration that we were silent when we shouldn't be, but she was acquitted. Footnote number 2. Other cases cited by the trial court on this issue did not involve double jeopardy challenges at all. And these must be cases that Judge Canoni cited in her order. See Commonwealth v. Zacharias, Commonwealth v. Floyd P. Instead, these cases both vacated convictions where courts responded to ambiguous communications by jurors in such a way as to improperly influence the return of guilty verdicts. Given the gravity of a criminal conviction, it makes sense to insist on observance of procedural formalities before taking away a defendant's liberty. However, in light of the fundamental constitutional prohibition on double jeopardy, refusing to give effect to a verdict of acquittal due to a lack of formality is another matter altogether, for which neither the Commonwealth nor the trial court has cited any precedent. Additionally, unlike in Zacharias and Floyd P., there's nothing ambiguous or tentative about the post-trial evidence of verdicts here. The instant case squarely presents that issue, and the defense respectfully submits that this court should hold that any lack of formality does not supersede the defendant's fundamental constitutional protections. This issue is one of existential importance, not merely to Ms. Reed, but to the very foundation of the constitutional safeguards that protect her. And I agree with that 100%. I'm a constitutionalist. 2. Alternatively, the defense is at least entitled to conduct post-verdict inquiry. The law is clear that, at least in the context of juror bias, an affidavit by counsel is sufficient to entitle the defendant to a post-verdict inquiry on the issue. Commonwealth v. McCallop. Okay. McCallop was the case. If you live in Massachusetts, you may remember this case. It was regarding the murder of, I don't want to misname her, but I think her name is Krista Worthington. Happened on the Cape many years ago where, and I'm only using race as a descriptor here, where a Black man was convicted for the murder of Krista Worthington. I think he was also her garbage man. And in that case, the court did call the jury back in because they found that there may have been some racial bias during the deliberations. So if you know the Krista Worthington case, that's the case of McCallop. No less than the right to an unbiased jury, it is the fundamental tenet of our system of justice that a defendant may not be retried for a crime of which she was previously acquitted by a jury. And the defense submits that post-verdict inquiry is equally warranted in the present context. Other than generally noting that this case does not involve an allegation of juror bias, the trial court did nothing to distinguish McCallop. But there is no apparent reason to limit a defendant's entitlement to a post-trial inquiry to the issue of racial bias alone. Recently, in U.S. v. Saranev, the First Circuit Court of Appeals remanded the matter for further proceedings in the Boston Marathon bombing case due to two jurors' postings on social media regarding the bombings and the district court proceedings, which came to light after the jurors had been provisionally selected to serve. The comments did not reflect racial bias in any way, but rather possible bias specific to the defendant. The comments were also inconsistent with the jurors' assurances that they had not discussed the case online. The First Circuit held that the district court erred by failing to inquire about these issues with the jurors. Given that the right to an impartial jury is a constitutional bedrock, where there is a plausible claim that a prospective juror lied in a manner that may reveal bias, a court need conduct some inquiry reasonably calculated to determine whether the prospective juror did lie, and if so, why. Crucially, for present purposes, the First Circuit Court ordered the district court to voir dire the jurors. In doing so, the court acknowledged, no doubt any juror would have strong incentives to avoid admitting having committed perjury during voir dire. We also expect that most jurors, having taken time out of their daily lives to receive evidence at trial, deliberate with other jurors, and reach a verdict that they believe is just, would prefer not to have that verdict disturbed, especially as a result of their own actions. We have no doubt that the able district court judge can do what judges regularly do: form a considered opinion about the sufficiency of the jurors' explanations once those explanations are given and explored. That case, let's see what it was from 2024. It's brand new. First Circuit federal case regarding the Boston Marathon bombing. The appellate court sent it right back to the lower court saying, yeah, you need to call the jurors back in. Okay. In another high-profile case, the South Carolina Supreme Court recently agreed to hear claims by Alec Murdaugh that during his murder trial, the clerk of the court improperly influenced deliberating jurors. Murdaugh has entered the chat. I was so confused. Melinda, who gets the initial shout out for sending me these documents, when I was looking through them, one of the attachments is whatever they call it here, Exhibit B. Exhibit B was Murdaugh. And I thought, this must be a mistake. Why are there Murdaugh papers in here? But look at that. Karen Reed's defense attorneys bringing Murdaugh in. I did not have Murdaugh on my bingo card today, other than what I saw earlier when I saw those papers were attached. I'm like, oh, this must be a mistake. The order in Murdaugh is attached here too as Exhibit A. Jurors came forward after the clerk published a book about the trial describing her efforts to obtain a guilty verdict through improper jury tampering. The brief of the appellant is attached here too as Exhibit B. The clerk allegedly told jurors after the defense began its case to not let the defense throw you all off or distract or mislead you. and warned them not to be fooled by Mr. Murdoch's testimony in his own defense. The trial court held an evidentiary hearing on the motion for a new trial, including testimony by jurors. As in Saranev, the issue was not racial bias, but nonetheless implicated fundamental constitutional rights like Ms. Reed's right not to be retried for offenses of which she has already been acquitted. Look at Alec Murdoch sneaking in here to the SJC of Massachusetts. And Scott, are you here? When I found out that Becky Hill was in all of this trouble and her co-author was making claims that they had removed the book from publication and from all sources of publication and sales, I, of course, immediately ran to Amazon, where I purchased a copy of the book for myself and for my moderator, Scott. And I sent it to him. I don't know if you've read it, Scott. I haven't even cracked it open myself, but I thought it would be such a great thing to have because that book will never be found again. So how crazy is that? All right, back to the document. You started it? You actually did start it? No, but isn't it just such a great souvenir to have of our true crime history together? Because nobody will be able to find that book ever. And the Supreme Court of the state of South Carolina has agreed to hear the Murdoch case. So there is a very good chance that he would be getting a new trial. Or wait, did they already agree that he would get a new trial? I don't know. I'm conflating all of my cases now. But I said, when we read those papers, I said, I don't think he's getting a new trial. Because what she did is unforgivable. And completely improper. It's like textbook jury tampering. Textbook. All right, my lips are dry. Talk amongst yourselves for a second while I try and remedy this. Give me a second. Okay. Moving on. The trial judge dismissed Ms. Reed's reliance upon Sarnev and Murdoch in a brief footnote, simply stating that the circumstances are readily indistinguishable. Readily distinguishable from those that issue here. But this misses the forest for the trees. While it is certainly true that all three cases raise different issues, the fundamental point remains the same. A defendant who comes forward with credible evidence of a serious constitutional violation post-trial is entitled to an opportunity to prove those claims. There's no apparent reason to artificially limit the availability of such constitutional inquiry to the singular context of racial bias. I happen to agree. When it becomes time to expand the law, it becomes time to expand the law, right? The defense request does not in any manner infringe upon the substance of the jury's deliberations. To the contrary, the motion to dismiss was predicated solely upon the result of such deliberations, namely a unanimous decision that Ms. Reed is not guilty of murder in the second degree. The relevant inquiry could be accomplished by a single yes or no question posed to jurors. Did you unanimously acquit Karen Reed of the charges on counts 1 and 3? What did I say earlier? I haven't even read this yet in its entirety. Of course, the results of a jury's deliberations are not secret. They are, in fact, routinely announced in open court. Here, the defense has learned post-trial that the jury reached a verdict that was not so announced. It was at least entitled to the opportunity to substantiate that fact in order to ensure Ms. Reed is not unconstitutionally forced to stand trial for criminal offenses of which she had already been acquitted. Such inquiry in no way intrudes on the deliberative processes of the jury. Deliberative process. Indeed, it was the trial court, not the defense, that injected issues regarding jury deliberations into the inquiry. It is simply not true that given the context of the jury's final note to the court, an inquiry would necessarily require the court to understand why the jury's final note communicated a deadlock on charges when post-trial certain deliberating jurors are purportedly stating that the jury was in fact unanimous on most of the charges. As explained herein, pages 28, 29, in light of the trial court's instructions repeatedly characterizing the lesser included offenses within count 2 as discrete charges, the jury's note is readily susceptible to interpretation consistent with the post-trial evidence supporting the defense motion. Footnote 3. This distinguishes the case from a juvenile where the jury foreman had expressly indicated that the jurors were deadlocked on the complaint, which charged murder. And the jurors subsequently reaffirmed that fact in open court. So they were polled in the juvenile case. In these circumstances, a post-trial subpoena to the foreman regarding verdict slips recovered from the deliberation room after trial regarding that very count could only be aimed at impermissible impeachment months after the fact of the jury's report to the judge in open court. Here, by contrast, no statement or inquiry was made regarding whether the impasse related to any specific count. See also Fuentes, which says, jury note expressly stated that the jury could not reach a unanimous verdict as to either of the two indictments. In any event, even if the jurors state that they acquitted Ms. Reed, no further inquiry. All right, I read that wrong. In any event, if the jurors state that they acquitted Ms. Reed, no further inquiry regarding the contents of the jury note could possibly remove the clear constitutional implications of such acquittal. Footnote 4. In Commonwealth v. D. Benedetto, the defense argument that the jury's verdict, which had just been announced in open court, was not in fact unanimous depended upon juror testimony concerning internal deliberations, namely that they misunderstood the unanimity instruction. D. Benedetto also preceded this court's opinion in McCallop, and therefore it must be disregarded to the extent the court perceives an inconsistency between the two. Break for a second. Some frantic messages here. Hang on. Thank you, Screaming Mimi Sue, for becoming a new member. Thank you so very much. Welcome. Ginger Avenger, thanks for the 10. Since the jurors left the forum blank, wouldn't that be an innocent vote? Judge Bev said not guilty if blank on the record. Well, yeah, according to her reasoning, wouldn't it? I don't know if the verdict slips were ever collected. That's an interesting point. Were the verdict slips ever collected? Where are they? Did they fill out counts 1 and 3 and not the sheet on count 2, or did they fill nothing out? And where are they now? That's why the jurors, in my opinion, should be questioned, but she doesn't see it that way. Mandolin Wind, thank you. Thank you for being a member for 4 months. No, thank you. Diane, do you feel these filings are a good idea? Oh, 100%. 100%, Diane. Thanks for the 5. In my opinion, yes, I do. 100%. I think that double jeopardy is one of the one of the cornerstones of the Constitution of the United States of America. How could you not? How could you not stand up for the Constitution and for the rights of every American to not be tried twice for the same crime? Our founding fathers are rolling over in their graves right now. Will it be granted? I don't know. My crystal ball's broken. But I do feel, in my opinion, this is an issue that needs to be broadened in the state of Massachusetts if there's no case law that's directly on point. That's why they're citing a lot of cases from the U.S. Supreme Court. And one case that was just decided this year. Hello, Scott McGinnis. Thank you for the 10, for tuning in as always. Bev would have invoked Massachusetts Judicial Rule 27 if this were reversed. In other words, a guilty on count 2 would have been accepted, and a not guilty on count 1 and 3 and entered into the record. Mission accomplished. What do you mean a guilty on count 2? They were undecided on count 2. So they would have, what would have been entered would be not guilty on counts 1 and 3 and a mistrial or no verdict on count 2. She would be retried on count 2 only. So I'm not really sure if there's a typo in there or if you're trying to tell me something else, Scott. But thank you so much for the super chat. Okay, Scott, thanks for your text, but I can't look at that right now because that's a totally different case. I'm trying to stay on topic right now, but thank you for that. Give me 1 second. Mark Betterow is here. I mean, he's here on my phone. See if he wants to jump on after I'm done reading. I'm not sure if he's in court. I don't know where he's right now, but I know you always like to hear from him. So let us keep going. Point 3. Re-prosecution is independently barred. Okay, he's saying what time? Let's see. How much time do we have? Hold on. Where were we? Point 3. Re-prosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was not deadlocked. All right. So Mr. Betterow is going to join us as soon as we're done reading, so he doesn't have to sit here through my reading. So hang on, folks. Hang on to your seats. Give me a second. To send him a link. The Canton Leaf Blower Society has decided to convene right outside my window. As always, it seems, when I'm on with you. So, there's that. Let's hope it doesn't drown out my own sound. Unbelievable. It's Gallagher out there with the leaf blower. He put his retirement papers in, by the way. Did you see that? We talked about that last night. All right, moving on. Let's try and get through this. Re-prosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was not deadlocked. Absent the defendant's consent, state and federal double jeopardy protections bar, as a general rule, retrial of a defendant whose initial trial ends without a conviction. This rule is rooted in the importance to the defendant of being able once and for all to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate. Importantly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. And this burden remains solely upon the Commonwealth, regardless of whether or not a defendant objects to the declaration of a mistrial. Before a court declares a mistrial for manifest necessity, 1, counsel must have been given the full opportunity to be heard, and 2, the trial judge must have given careful consideration to alternatives to a mistrial. Citing Taylor. Here, the defense respectfully submits that the lack of opportunity to be heard alone is dispositive. Upon receiving the final jury note, the court declared a mistrial and excused the jury without consulting counsel. This action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. Citing Picard, finding no manifest necessity where no opportunity was given counsel to argue the propriety of the question or of the necessity of a mistrial. Stewart, which found no manifest necessity where the trial judge first ruled that he was going to declare a mistrial and then, almost as an afterthought, unenthusiastically asked whether counsel objected. Well, that's interesting because in that Stewart case, the judge actually asked if there was an objection, and that still was found to be no manifest necessity for a mistrial. So there you go. The defense was provided no opportunity to object to the declaration of a mistrial or to advise the court of the imperatives of Massachusetts Rule of Criminal Procedure 27B, request that the jury be polled or discuss the issue with Ms. Reed. The defense respectfully submits that given the importance of double jeopardy protections and the profound implications of a retrial for a criminal defendant, an opportunity to be heard must, in order to be meaningful, occur after a reasonable opportunity for counsel to consult with their client. Citing some cases which say, among other things, that some basic trial choices are so important that an attorney must seek the client's consent in order to waive the right. Counsel for Ms. Reed clearly had no such opportunity here. Footnote 5, which says, notably, the trial judge did ensure Ms. Reed was personally consulted regarding less weighty matters. For example, on May 24th, 2024, the court called Ms. Reed to sidebar and personally asked her to verbally consent to Attorney Jackson's absence on the Tuesday following Memorial Day, and that co-counsel Attorney Yannetti could represent her on that day. See May 24th, 2024 transcript at pages 3 to 5. Let me just see something, because I don't think that's the part that they asked to be sealed, did they? Hold on a second. We were trying to figure out what the sidebar was, or what the sidebar was about that they wanted to be sealed. And I don't know where that is in this document that I'm looking at. It's not in the appendix 3. It's not pages 3 to 5 there. Okay, maybe it is. Where am I? Whether or not the trial court was obligated to obtain Ms. Reed's personal consent, its failure to at least ensure that counsel had an opportunity to consult with Ms. Reed on the issue undermines the existence of manifest necessity. The record is independently lacking on the second prong, as it reflects no careful consideration of alternatives to a mistrial. Citing Taylor, here there was one obvious alternative: to simply ask the jury to specify the charges on which it was deadlocked. This option is apparent from the face of Rule 27B, which states that the judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree, and direct that such verdicts be received and recorded. Emphasis added. That's Rule 27 for those of you who are asking, and for Scott, who just put up that super chat, and that is what Scott was saying. In fact, the reporter's notes expressly indicate that such reception of partial verdicts is required before a mistrial may be declared for manifest necessity. See Rule 27 again, reporter's notes. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. Had the court inquired as to the existence of any partial verdicts, and the jury articulated its verdict consistent with the statements of juror A, B, C, D, and E, the double jeopardy implications would have been clear and decisive. Indeed, with virtual unanimity, the cases have applied collateral estoppel to bar the government from relitigating the question of fact that was determined in defendant's favor by a partial verdict. In denying the motion to dismiss, the trial court erred by relying primarily upon the lack of objection by defense counsel. In doing so, it utterly neglected to acknowledge the clear and long-standing case law, placing the burden of establishing manifest necessity squarely on the prosecution. Nickel provides a helpful analog. Let's see how long they talk about Nickel. And then I will just tell you there is some discussion about this case known as Nickel, because we are going to have Mark come on at 2. And so we will just FF a little bit through this. But I will scroll by slowly in case you want to come back and read what the court said about the Nickel case. The court respectfully requests, the defense respectfully submits that the same result is required here. It is the prosecution's burden alone to ensure that the declaration of a mistrial is supported by manifest necessity. Even where, unlike in the present case, defense counsel was expressly offered the opportunity to be heard on how to proceed and explicitly shared the judge's mistaken view that the trial could not continue with fewer than 6 jurors, this court held that the alternative to declaring a mistrial was not adequately considered. Here, there is no doubt that the court was permitted to accept a partial verdict. Going back to Rule 27. But the record simply reflects no consideration of that option. Accordingly, as in Nickel, the charges in this matter must be dismissed. Neither Ms. Reed nor her counsel consented to the declaration of a mistrial. Consent may be implied where a defendant had the opportunity to object but failed to do so. But the law is clear that such consent may not be inferred from counsel's silence alone. And that's what the Commonwealth wants you and me and the public and everybody else to believe. And all the twits out there spewing this. Burden was on Jackson and Yannetti to object. And they didn't. So they lose. But apparently the law is clear that such consent may not be inferred from counsel's silence alone. Citing Commonwealth v. Edwards, rejecting the argument that the defendant consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed. In another case, holding that where the trial judge did not ask defense counsel to comment on the possible declaration of a mistrial, the lack of an objection from defense counsel cannot be construed as consent to such action. Here, no consent was sought, nor was it given. And those are two cases from 2022 and 1996. The trial court's ruling that Ms. Reed's counsel impliedly consented to the mistrial was based primarily upon counsel's request for a Tui Rodriguez instruction. Of course, whether the jury has engaged in due and thorough deliberation to support a Tui Rodriguez instruction and whether there is manifest necessity to declare a mistrial are distinct legal questions. In fact, the Tui Rodriguez charge is designed to urge the jury to reach a verdict, not to avoid one. It's also known as an Allen charge or a dynamite charge in other states. Unsurprisingly, neither the Commonwealth nor the trial court cited any case finding a defendant's consent to a mistrial can be based on a prior request for a Tui Rodriguez charge. Here, defense counsel's request did not reflect any implicit concession that the jury was deadlocked on all counts, nor did they commit the defense to any position regarding whether the court should sua sponte declare a mistrial. If it is true that if the jury reports an impasse after a Tui Rodriguez instruction, they shall not be sent out again without their own consent. That fact, however, does nothing to undermine the alternative of simply inquiring, pursuant to Rule 27, whether the jury had reached any partial verdict. Doing so would not require the jury to be sent out again. The trial court was in error in equating a request for a Tui Rodriguez instruction with any acceptance of or acquiescence to a mistrial. Moreover, the trial court's characterization of the jury's final note as, quote, making it clear that the jurors would not consent to continuing their deliberations, end quote, is belied by case law cited in the court's order. In Commonwealth v. Jenkins, the jury similarly reported after a Tui charge that they felt strongly that there was no hope of progress and requested further instructions. The court responded by telling the jury, I cannot force you to continue deliberations unless you agree to continue deliberations, but then asking them to retire and decide whether further deliberations on the next day would be fruitful. The jury promptly reached a verdict in that case. This court held that the object of the statutory prohibition on sending the jury back out without consent was fulfilled because the jury consented to continue their work. The jury's return of a verdict after sending their last note implicitly satisfied the statutory requirement of jury consent. Thus, another alternative to a mistrial, which the trial court did not consider, in this case would have been to A, inform the jury that it could not be required to continue deliberations without its consent, and B, ask it to retire to consider whether it was prepared to return any partial verdict. Seems so simple, doesn't it, when they just put it like this? Here, neither Ms. Reed nor her counsel were provided an opportunity to object to the declaration of a mistrial, as opposed to the appropriateness of a Tui Rodriguez instruction. All the cases cited by the trial court on this issue are readily distinguishable on that basis. For example, in Pellegrin, a witness testified at trial to incriminating evidence that had not been disclosed to the defense. This court held that the defense had an opportunity to object, given that the mistrial was declared after a voir dire of the witness and colloquy after the jury were cleared from the courtroom. Here, by contrast, the defense did not learn of the contents of the jury note or the court's intention to declare a mistrial until the judge called the jury in and stated the declaration of mistrial on the record. Counsel was never shown the note from the jury. The judge indisputably never informed counsel of his intent to declare a mistrial, much less solicited counsel's views on the matter. Just going to skip through. As the appeals court has explained in an analogous factual context, the suggestion that counsel could or should have immediately objected to the sua sponte declaration of a mistrial underestimates or ignores the difficulty of reaching a decision in which the defendant has an evident personal stake, whether the defense would be advantaged or the opposite by a second trial. The possibilities ahead, such as the appearance of a new prosecution witness, cannot be instantly calculated. Therefore, to equate silence with consent when the occasion comes abruptly and unexpectedly seems quite unwise. The trial court's suggestion that the defense counsel had an opportunity to object to the declaration of a mistrial after it had occurred and the jury had been discharged is mistaken. The judge expressly told the jurors, "Your service is complete. I am declaring a mistrial in this case." Given counsel's lack of an opportunity to be heard and the lack of the court's consideration or of alternatives, the defense respectfully submits the prosecution has not satisfied its high burden of establishing manifest necessity for the mistrial. While the trial court correctly observed that the jury deadlock may be grounds for a mistrial, it cited no precedent for the counterintuitive proposition that a deadlock with respect to some but not all counts constitutes manifest necessity for the declaration of a mistrial as to all. Compare Fuentes, which affirming declaration of mistrial, where note expressly stated that the jury could not reach a unanimous verdict as to either of the two indictments. This lack of precedential support is no accident. Such a rule would run counter to the important interests underlying the constitutional safeguards against double jeopardy. Contrary to the trial court's suggestion, there was nothing in the jury's notes that directly contradicted the post-trial affidavits by counsel. As an initial matter, there is a facial tension between this observation by the court and its stated acceptance of the affidavits as true for the purpose of the motion to dismiss. And the jury's reference to the charges is easily reconciled with the post-trial affidavits affirming that the only deadlock related to the lesser included offenses of count 2. Indeed, the court repeatedly referred to those lesser included offenses as distinct charges, both in its initial and supplemental instructions to the jury. There are the receipts. In this context, the jury's note was facially susceptible to two alternative interpretations. One, that the jury had reached an impasse as to all charges, or two, that the deadlock applied only to some of those charges, e.g. on multiple lesser included allegations within a single count, such as count 2. The information received from jurors post-trial proves the latter interpretation was correct. The jury's failure to expressly mention its agreement on counts 1 and 3 is understandable in light of the court's instruction that it should continue deliberating until it had reached a final verdict on each charge. This court's holding in Commonwealth v. Roth that courts should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. Roth was rooted in the belief that inquiry concerning partial verdicts on lesser included offenses have not been separately charged carries a significant potential for coercion. See also Bluford. Such inquiry, in effect, implies that the jury should consider conviction on the lesser count. No similar danger is present, whereas here the jury was asked to return 3 separate verdicts on 3 separate counts. Contrary to the trial court's suggestion, an inquiry regarding whether the jury had reached a partial verdict on any of the 3 separately charged counts would not necessitate any forbidden inquiry on the lesser included offenses contained within count 2. There's simply nothing coercive about asking a jury reporting a deadlock that fails to specify which counts the deadlock relates to the single question of whether its deadlock is on certain but not all counts, and if it has reached a unanimous verdict on any counts. The inflexible prohibition on judicial inquiry regarding partial verdicts advocated by the Commonwealth would inevitably undermine defendants' important and constitutionally protected interest in being able once and for all to conclude their confrontations with society through the verdict of a tribunal they might believe to be favorably disposed to their fate. It is uncontroverted. Let's see. The Commonwealth's proposed rule would also undoubtedly hinder law enforcement interests by precluding courts from asking whether a jury may have reached a guilty verdict on some but not all standalone counts. It is uncontroverted that according to the jury of her peers, following trial, Ms. Reed was unanimously found not guilty of counts 1 and 3. That undisputed fact must not be lost in this analysis. It bears repeating that at the heart of this policy against double jeopardy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression. Conclusion. For the foregoing reasons, Ms. Reed respectfully requests that this honorable court reverse the trial court and order that counts 1 and 3 must be dismissed. XOXO. Martin Weinberg, Michael Pabian, Alan Jackson, David Yannetti, dated September 11th of 2024. Whew, we did it. We did it, my friends, and it only took 1 hour and 53 minutes. And we have Law Daddy here with us to say hello. Say hello, my friends, to Mr. Mark Betterow, attorney at law. Hi.
How are you?
I have a hoarse voice now from reading that whole thing aloud. How are you?
Okay, good.
Did you get a chance to read it, or did you get to listen to my ASMR voice reading it?
No, I perused it when it was sent out by somebody this morning, and between doing my own heavy writing for something interesting coming up very, very soon, it was a very interesting brief. I thought it was very well done and really laid it out, and dare I say it, favored substance over form. So put that on the bingo card. That's one.
Murdoch was not on my bingo card, number 2. In fact, when I got this originally this morning and I was looking at all the exhibits, I'm like, why is all this stuff from Murdoch? It must be a mistake. But no, they cited Murdoch in their papers.
Interesting that they included all the Murdoch stuff. And of course, the interesting thing last night was everyone was trying to speculate about this vaunted sealed transcript and what does it relate to and this and that. And it's interesting. It just relates to the point that the judge apparently wanted clear attorney-client consultation and input on, something that is important, but not as important as declaring a mistrial. So I thought they actually used that very effectively. It turns out the transcript they wanted was nothing more than the judge calling up the client to confirm that she agrees and approves of one of her lawyers taking a day off for a prior engagement, and nothing more, nothing less. They very effectively weave that into their brief and saying, why wasn't there a chance to consult with the client over something as important as the consequences of a mistrial and whether we should be heard or not. So very interesting, very well done. And I mean, the thing that kind of hangs over all this for me is sometimes the law has to change for the better. I mean, that's kind of the way the American system works. It's case law. It evolves. There's precedent, but the way the whole concept of case law works is sometimes there are things that are unique and haven't been handled before, and prior precedent doesn't always apply. You know, you can't always use something that is sort of similar but not really as precedent over something that's a little bit different. And when you're talking about something as important as being tried twice for the same crime after which you were first acquitted, that's pretty important that you be confident in that. And you know, this idea that, well, they didn't publish the verdict and literally tell us doesn't seem like a basis to just not consider the obvious fact, which is, even since the last time we spoke, gotten stronger and stronger. Another juror has come out, given interviews. Jurors have now spoken to more than one member of the media. There's 5 affidavits. No one has disputed this. The DA hasn't disputed this. The court kind of accepted it, that there were acquittals. So why not at least explore and confirm that that's true, and find out why the verdict wasn't published and go from there. So I don't know why this is such a difficult concept to say that it is a case of first impression, generally speaking. So maybe the court ought to take that into consideration. I also thought their argument about the right to be heard on the mistrial was pretty good, actually. Everything that, you know, we had talked about this. I know they never got to see the note in advance. And I think that the trial court's assumption that you are not shrinking violets, so you didn't jump out of your chair, is not, you know, not a great argument in light of the fact she didn't show him the note and immediately said, I'm declaring a mistrial. And I really like the part about a decision like that, at a minimum, requires consultation with the client. We didn't have that opportunity. So, you know, under the circumstances, I thought the papers were really good. I don't know what's going to happen, but
I know.
well
I
done.
don't either, but you know, silence is acceptance, really, in such an important case as this, when there are 3 clearly separate verdict sheets. Like, how much energy would it have taken to, and the way she said, I'm going to come back and talk to you in a minute in private.
Yeah.
Well,
Yeah.
you know, like, why couldn't you go talk to them in private before you declared the mistrial? Why couldn't, you know, there's so many things that could have happened differently that would have saved this whole, you know, mishigas from happening right now. You can take this one because I've been talking for 2 hours. What is manifest necessity? The cat lady would like to know.
Legal mumbo jumbo for when there's a mistrial, a finding that's necessary to allow a second trial to happen after the attachment of jeopardy. So it's just a term of art in double jeopardy jurisprudence, if that's even a thing. Without the finding of a manifest necessity, you can't retry someone after a mistrial because jeopardy has attached. But in the existence of a manifest necessity, the law is clear under the U.S. Supreme Court precedent that you can. And in the ordinary course of business, when there is a hung jury mistrial that is not disputed, that is clearly a manifest necessity that would allow a second trial. But the issue here is that the court did not determine properly that there should have been a manifest necessity before just declaring a mistrial. And if that were to happen, then double jeopardy kicks in, because without a manifest necessity, you can't have a retrial. And they're arguing that you didn't take the steps to determine that there was a manifest necessity for a mistrial. You know, was there a partial verdict? You didn't give the defense a right to be heard after consulting with their client, all of that kind of stuff. So,
so it's the legal standard by which the court should rule or declare a mistrial. Amber says, thanks for the time. For sidebar sealed, I saw on X. Oh, don't get your news from X, honey. It was regarding why Higgins' interview was occurred in Sharon, Massachusetts. After sidebar post Lally objection, they moved on. Not sure if that's true. Yeah, somebody had said that it was like a rehab. There was a rehab facility in Sharon, and maybe that's why, because it was HIPAA related. I don't know, Amber, but now based on these papers, I think we can agree that it was the sidebar when they called Karen up to say, is it okay with you because Alan Jackson's not going to be here on Monday, that Yannetti takes over the cross of Higgins, right? Because that's what happened.
Yeah, if I recall correctly, he had a prior engagement. Things were
Yeah.
dragging on. He had to go, and the judge, understandably, wanted to make sure that the client was comfortable with that and consented to that. And no, I mean, it's really not that big a deal standing alone. But I like the way that they emphasized if you took the time to make sure lawyer and client had to consult and satisfy yourself about that. Certainly a lesser concern than, I don't know, getting tried after you were acquitted for murder. That seems to be a higher concern, that you didn't even give lawyer and client a chance to discuss how to respond. You just declared the mistrial and said, we're done here. So I think there's no question that's what the sealed transcript relates to. It relates to that discussion. It has nothing to do with Brian Higgins and rehab facilities. And
why would they seal it though? Why would they impound that? Just because it's attorney-client privilege? Because they were.
I don't know why the judge initially wouldn't do that I mean, she did a lot of things on the record, yet at sidebar and apparently sealed. Again, culturally, Massachusetts is not my home court for this kind of stuff. I don't know why that would not be done on the record. I know you would agree in New York, it would be very simple that a record would be made from the table with lawyer and client saying, Your Honor, I can't be here tomorrow. Miss Reed is aware of that. She agrees. And the court might say, Miss Reed, is that true? Are you comfortable? Blah, blah, blah. Yes. And that's it. I don't know why any of this would need to be done confidentially or at the bench, but that's how they do it there, I guess. I don't know.
That's how we do it in Massachusetts, Mr. Jackson. Thank you, Colleen St. Ange, for the $50 super chat. You are so very generous as always. Love you with all of my heart. Ginger Avenger, thanks for the 10. Same question for Mr. Betterow. If the jurors left the sheets blank, wouldn't that be not guilty according to Judge Bev's statements on the record?
I don't know. I mean, this is all so confusing and silly and whatnot. And the verdict sheets there, they look convoluted. The instructions feel convoluted. The jury goes back after 3 months or whatever it was without any chance to even refresh themselves on what the evidence was, which feels convoluted. You listen to these recent interviews with jurors who are saying things that, at first blush sound crazy, but then you say, well, how the hell can they remember what they heard, which is convoluted. You realize now in hindsight that giving the lawyers only an hour to sum up is actually not enough time in this particular case, which feels convoluted. And it's really not surprising that this would end up in one big mess that it is. I mean, everything about this case is convoluted.
Yeah, I agree. Do you feel that these filings were a good idea? That the appeal was a smart thing to do?
Yeah. I mean, first of all, if you get the right single justice who, I don't know, is more concerned about getting tried after being acquitted rather than the law since 1742 is that if you don't publish literally the word not guilty, that stop listening and we're done here. I think that would be a concern. Two, if they win, obviously it's a good idea, right? You wipe out the murder case. But number three, and this is why these guys are probably playing chess versus checkers, the more it stays in the news that she was acquitted, and the more the jurors talk, the prospective jurors are hearing this, it's more pressure on the DA. It's more common sense that this case is convoluted. And so really, isn't the defense at this point playing with house money? And I mean, why would the DA retry her for murder anyway? I mean, that would just be profoundly stupid if they did that. So this is pure house money for them, and they just might win something out of it. And if they don't, they'll certainly get good attention and news coverage heading into a potential retrial on whichever counts they end up retrying her on anyway. So yeah.
How much time does the Commonwealth have to file their responsive briefs?
No clue on Massachusetts.
Like 30 days maybe?
I mean, I'm sure it's accelerated to some extent.
Yeah.
I mean, they have a very strange process there. It's going to go in front of one judge, and then that one judge could theoretically kick it to the whole court or send it back, order a hearing. any number of things. It's kind of surprising that one judge would determine whether she can be retried for what factually is almost certainly an acquittal on 2 counts. But that's how they do it there. So, but in terms of the actual procedure on deadlines on Massachusetts appellate procedure, I'll confess to having no clue.
Well, I'm thinking New York. I mean, just let's think of New York, right? So, I mean, it's like 30 days, right? You have 30 days to perfect. You have 30 days to file your notice of appeal. Then you have, I think, 30 days to perfect. No, maybe you have 6 months or I don't know.
Yeah, but what's interesting is, so first of all, in New York, this would have been in the form of like, a 440-10 hearing, a post conviction. Well, actually, it's not a conviction. No, it would not strike that.
Right.
It would not be, but it would be all kinds of litigation. You would argue it in front of the trial court. It would go to the appellate division. I mean, you wouldn't,
Right.
they're skipping a step.
How
here.
are they leapfrogging there? Because they do have an intermediate.
It's in that Massachusetts statute. I actually looked it up today. And it goes to one judge, where in New York, you would just have to literally fight this process. But in New York too, you wouldn't have a right to be heard on this yet. I mean, this would be the kind of thing where you would make a strong argument in front of the trial court. You would preserve it for a future appeal, but you would be appealing if you come in second, which in a criminal case is not good. You wouldn't be stopping the trial with this kind of stuff. So it's a whole different process, but it appears to be moving a hell of a lot quicker than it would move in New York. But in New York, ultimately, you would never have a single judge considering this. The only thing a single judge would ever consider is leave to appeal to the New York Court of Appeals, the highest court in New York, because it makes too much sense to call it the Supreme Court, which is actually the lower court. But other than that, you would get a whole panel of judges and be going on for months and months. So
yeah, it's a whole different set of skills being an appellate attorney. Thank you, Kathleen Powers, for 2 super stickers. And to David Reese, who says he just received a phone call from a John O'Keefe. Somebody's spoofing you. Do not answer. Do not answer. Marcello, hello to Argentina. Bev didn't bother to call the jurors, so at least all 12 jurors can say we acquitted, just for the record. She can deny it 100 times if she wants, but again, that would make her look worse once they say it.
The fear here is, by not doing that and issuing the ruling that she did, it's not inconceivable that the ruling of whether it's the single justice or the whole SJC, as they call it, they could theoretically kick it back for a hearing. I mean, then you're talking about what a colossal waste of time, several months, when the trial judge could have done was say, you know what? I'm not going to accept these affidavits as proof of an acquittal, but it's a good faith basis to bring them in, ask them the questions. I was very happy to see that they argued what we've been saying. This is not an assault on deliberations. It is literally, I don't want to know how you got there, but what did you come up with? That's it. As I think
just the result.
It could literally be one question, as he said. And then if you satisfy, if the court made a factual finding that it's 12 out of 12, no question that there were acquittals on those counts, then go to the next central question, which is, why didn't anybody tell me? And again, I don't know what the answer officially would come out and what the finding would be, but based upon a recent interview of a juror anyway, if part of the reason appears to be that the foreperson felt that they didn't have to do that against the wishes of other jurors, well, that's kind of scary and not good. And how could anyone say with a straight face that is the buffer that prevents, or allows a retrial of an in fact acquitted murder defendant to be retried? I mean, this is crazy in many ways.
And if there's no precedent, maybe it's time to expand the law. I mean, that doesn't mean that you just can't rule, there's no cases on point, therefore I'm just going to deny it.
That is such a ridiculous argument in this context, given that there is no precedent. You're talking about double jeopardy, and there are, as the defense very capably notes, there are circumstances in which jurors can be brought back. And, whether there was racial bias, whether there was outside influence, whether the clerk, as they cite in Murdoch, got into this. How are those any worse than Your Honor, we actually acquitted on 67% of the counts, but we didn't know how to make that clear. And the foreperson, for whatever reason, chose not to notify you. I mean, to say that, well, there's no precedent of this. And, if they were claiming that there was a racial animus against her, which there's not in this case, obviously, that, sure, certainly we would allow them to come back in. I mean, aren't you kind of splitting hairs here? How could you not allow, based on the record that is made here? And this isn't going to open the floodgates. It's not like every day you're going to have defendants saying, I was contacted by 5 jurors in the span of a week, all saying, wait a minute, we acquitted on that count. What are we doing here? And telling multiple members of the media, this is crazy, we acquitted. So, I mean, this is a very unique circumstance in a very unique case. And I think to just bury your head in the sand and pretend it doesn't matter because the foreperson did not say, by the way, Your Honor, to be clear, we're hung on count 2 and the lesser included offenses, but we're good on the other 2 counts. It's form over substance. I mean, it's just.
And perhaps moving forward, it should be required that when there are multiple counts that a jury is deciding on, the judge must inquire as to whether they made whether they came to a unanimous decision on any of the counts. At least
a really interesting point. And, I wonder if it would have made sense for them to throw that in there, because everybody knows the way to attract an appellate court and lead them like the Pied Piper to where you want to go is to wrap it around, this goes beyond this case and the law needs to be clarified. And I think you just made a very, very good point that there is this confusion over this Rule 27 and partial verdicts. And wouldn't it be useful if the highest court in the state said, listen to us and listen very clearly and very loudly. Here's how it's going to be done, because this is not the kind of thing that we should be talking about whether an acquitted woman has to stand trial for murder again, and make it very, very clear that courts should do exactly this in these situations. And, that could also lead the legislature to clean up the rule a little bit. It's not uncommon that statutes get changed. And what better case to clarify this than pretty much the most high profile, controversial case in the state, and in which every juror is saying to anyone who'll listen, we did find her not guilty. I understand nobody wants to hear that legally, but factually it's what happened. And we're just going to ignore that. And that strikes me as crazy, at least until a juror said we in fact did not find her not guilty, or the reasons for not publishing it are unsatisfactory for whatever reason. But to just issue this ruling without even addressing these issues, to me, sounds crazy.
Could you see, should this SJC, as they call it, deny this motion, could you see the U.S. Supreme Court taking up this issue?
I don't know. I mean,
it goes to the heart of our Constitution.
It right? is. To be honest, the Supreme Court law on double jeopardy is not good for defendants. I mean, you even have that Bluford case, which is not really on point here, but it's not great. But if that were going to happen, of course, that would only come up after. They're not going to hear this case now. And the reality is it becomes moot, right? After Reed gets acquitted of all counts, which I assume eventually will happen. At that point, there's no case or controversy, so they wouldn't even be equipped to handle it. But certainly after, God forbid, for her sake, if she was convicted and exhausted her state appeals, then she would try, she'd have to start in the district court with a federal habeas and then try to get, to the circuit court in the First Circuit and then try to get to the Supreme Court. So if you're making that argument to go all the way to the Supreme Court, it's not good, because that takes years, and those are years in which you'd be incarcerated. So,
but even if there was a conviction on count 3, right? It's something that I think that they would look at.
It's interesting.
Opinion.
Right. But here's the other problem. there's no great factual record here. And obviously federal courts, habeas courts, they write this, and basically every denial of every federal habeas, we give the state court fact finding great deference, and we're not here to re-adjudicate the facts. And the questions are, what are the facts? I mean, the judge here didn't really take the facts. So the defense would kind of be hampered by the fact that the factual record is really nothing more than affirmations from two of her trial lawyers saying that we were told by jurors that, they found her not guilty. And of course, out of court statements to journalists saying, wait a minute, we found her not guilty. But that's not the kind of stuff that a federal habeas court is going to use to declare somebody not guilty. So that's the other concern. There isn't a good enough factual record to really present to a federal court. I don't think.
True. Hi, Blair. Will is here. Thanks for the 10. Should we worry about the fact that it was necessary for Jackson to file a pro hoc vice? Does it imply that there's a risk Jackson cannot represent Karen Reed in the next trial?
Not at all. He was admitted in the Norfolk County Superior Court, and this is the Massachusetts Supreme Judicial Court, and he needs permission as a non-member of the Massachusetts bar to appear in the court. This is formulaic. No, this has nothing to do with anything, but just because you get admitted to the trial level court doesn't give you carte blanche to appear in every case. And also, it's a different court, so it gets docketed differently. It's the first time it's been on, and he has to put in a notice of appearance, but he can't put in a notice of appearance until he's given permission. It's all formulaic, nothing. There's no risk whatsoever that he's not going to be involved at a retrial. Zero.
Exactly. It's just procedure. That's all it is. It's just a piece of paper that you have to file in every different court that you want to be admitted pro hoc vice in, which you recently had to go through in Massachusetts yourself. And it seemed like it was.
I did. It was, it was fine. I mean,
Easy.
It was a motion on consent. It's not a big deal. But for another example is, so there's another case, because there's a lot of these, which is in a different court. It's in a district court, and that's a separate admission too, as opposed to the Superior Court. So it's just for every court, you have to go through this rigmarole to get in.
Jumping through hoops, because it is an actual, privilege to be able to come into this courthouse, Mr. Betterow.
Costs a lot of money too.
Really?
Yeah.
Filing fees and all?
Oh yeah.
Oh, interesting. David Reese, it was a business call from John. So you have another client named John O'Keefe, David Reese.
Pretty common name, I would imagine.
What? John
O'Keefe's probably a pretty common name.
Yeah, I think so too. Thank you. Thank you, well hung jury, for your 5.
Hung jury.
Oh, I'm so far behind in this chat right now. Miss B, so if she gets tried again, she can't have a change of venue.
I don't know why she'd want to change a venue, but that's just one lawyer's opinion. But people out there think that the Norfolk DA's office is a disaster. They think that the homicide division, or whatever they call themselves, of the Massachusetts State Police, that literally live and work in the Norfolk DA's office, is a disaster. At least 3 of them are currently under internal affairs investigation. The Canton police are leaf blowers, solo cups, and all the other nonsense, and all this other thing. So that's how bad it was 3 weeks ago. Since then, you now have Sandra Birchmore, which is just horrific on every level. And it was the Norfolk DA's office who said, yes, we're good with suicide, based upon the investigative work of the Massachusetts State Police and the Canton police, who basically ignored how many warning signs that this at least appeared to be not consistent with a suicide. And then the medical examiner was a mess. And then, you get to the real boogeyman in the room, which is we can't find all these text messages on Farwell's phones. So every juror coming into the retrial, where the defense for Karen Reed is that these people are incompetent and or corrupt, take your pick, now is aware that these people swept they whitewashed the Birchmore investigation and just swept it aside as a suicide. And the feds had to come in and say, step aside, let the professionals work here, and took the virtually unprecedented step of bringing a federal murder case that is not part of some crazy RICO conspiracy or whatever, which is usually where they would do this. They don't prosecute murder cases. So I don't know why you would want out. And also look at the crowds outside that. I mean, it's 90% supportive. There are some other kind of people we've talked about before who seem to think and demanding that the DA ask for a retrial, ex-agents, those types of people. That's just bonkers. Never going to happen. Never would happen. Can you imagine a district attorney saying, Your Honor, I know in New York, you'd have to go to the appellate division.
Oh, you're not asking for a retrial. You mean asking for a change of venue?
Can you imagine the prosecutor?
Wait, yeah, no, that's what you're talking about. You said asking for a retrial. No, the DA wouldn't. Yeah, asking for a change of venue. I know.
We can't get a fair trial in our own county. Which, by the way, the proper response to that would be, sir, my recommendation is dismiss the case if you can't get a fair trial in your mind in your home county. But putting aside all the legal mumbo jumbo, that's just ridiculous. But I wouldn't move to change venue.
Oh no, I wouldn't either. I mean, especially based on the fact that people that live in Norfolk County have now a vested interest in the corruption in their police department locally, and their Massachusetts State Police investigators or case managers or customer service reps that are assigned to the Norfolk DA's office. And so I think that is the best place for this trial to happen,
you have at the very moment, you have 3 of the key state police witnesses against Karen Reed are under some investigation. You have one who you see the writing is on the wall, Proctor. I mean, they've already started moving away from him altogether. You saw the Brian Walsh thing.
Yep.
The other one who's critical, certainly if there's no Proctor, who becomes even more critical, is Buchanan, who they're kind of attached at the hip in their investigative work. We don't know what he's under investigation for or how serious that is. The other one who's under investigation is Tully, who is the one who can't count the pieces of taillight that he apparently vouchered, which is problematic. And then the other, I guess, important member of the state police, who at least we're told or haven't been told is under any investigation, is the cell phone extraction guy who missed all the Jennifer McCabe stuff and just completely biffed on Farwell's phone, and happens to be the one who's going to say, but trust me when I tell you that John O'Keefe couldn't have been in the basement based upon my evaluation of the electronic data, and he couldn't have been going up and downstairs based upon my investigation of that. So,
Trooperino, Guarino.
Other than that, it sounds like it's going great for them in terms of a retrial.
Who's left? Trooper Paul. Trooper Paul's going to be like the only remaining witness. And
I would suggest you have a better chance of being called as a prosecution witness than Trooper Paul. And I don't think you're getting called as a prosecution witness.
You never know. Thank you, Diane, who loves watching the two of us legal egos talk through complex issues with language for the general masses to understand. We hope you learn from us. That is very kind of you. Iceman says, he respectfully requesting Mark Betterow merch on your channel. Forget it, Jake. It's Chinatown, butt dials, double Jeopardy, juror emails. Never mind, they didn't check the box. What's for dinner?
Let's stick to the bingo, because the bingo's funny. No, I don't.
Are you doing bingo? All right, we should.
No, my cliches and funny expressions are apparently becoming a bingo sheet, which is funny.
It is funny. You're funny. You're funny. We got to inject humor into this, otherwise we cry all day.
You're gonna get me all good, fellas. What's so funny? What about me is so funny? The joke.
Like funny, like ha ha. You think it's funny, like ha ha?
I'm here to amuse you.
Do I amuse you? Yeah, that's a good one. If jurors create an alternate explanation, then shouldn't that equal not guilty? Because in Massachusetts, prosecution must convince the jury that there is no other reasonable explanation that can come from the evidence presented. Thank you, LA, for the 10.
Well, that's everywhere. That's not a Massachusetts thing. If the whole per se definition of reasonable doubt is if there is a doubt for which you can apply a reasonable position, or it's plausible, to use another word, that is per se reasonable doubt. And look, it's disturbing when you see some of those recent reports about what jurors are saying. And it's not a criticism of the juror. They're going on memory and all kinds of things. But this is a conversation for another day. But I'm telling you, there are certain cases. I am a huge proponent of bench trials. And this one's a little difficult given the forum that they're in. I get it. There's a lot of concern about that. But if this case were in a different setting, this to me, certainly on a retrial, would be a ground ball bench trial for me. But it's complicated in this case. I get it.
If it was a different judge, perhaps. Let's see. I am hearing from one of my sources at the SJC that there may be a conference today at 3 o'clock, a scheduling hearing today at 3 o'clock on one of the new SJC judges. And I'm not sure if it's regarding this case, and I can't reveal my sources because, a good reporter never does. And we are the new media, Mark. We are independent media at its finest. Thank you, LA, for your super chat. So who knows if they will schedule it? I would imagine they would have to put in their opposing papers before anything would be scheduled, though.
Oh, yeah.
So I don't know.
Yeah, they get
anything to do with this.
They get a right to be heard, whether you like them or not.
Yes, 100%. They do. Happy Thursday to you, Glamassus. Thank you so much for the 10. Your two favorite New York attorneys. Well, Mark's now a Massachusetts attorney as well, at least for purposes of one case.
Right.
So I'm sure you can't talk about that case at all, unless
Not
there's
really.
anything that you want to.
Hey, listen, whatever's public is public. Whatever's in the record is in the record. But there'll be more to say about it. There's a court appearance. What is today? Today is the 12th.
Today's the 12th.
Couple of weeks, things always come out in court and beyond. But, there's so much online back and forth with this kind of stuff. And the reality is the case has to be tried in a courtroom. If they choose to bring forth witnesses who claim things, they'll get cross-examined and the truth will be exposed. I mean, everybody knows cross-examination is the biggest benefit of truth and disinfectant to lies. And
it's the most fun thing to do, isn't it? When you're trying to case?
It is. But, that's the place for it. So, I mean, people are going to talk about it all the time and there's going to be back and forth. But, we stick to the strategy and winning in the courtroom and let the others do the talking outside, at least on that case.
Right. Will that be televised?
I don't know.
If your case is going to trial, is it going to be some crappy Zoom feed?
I don't know. I assume so, but I mean, I know a lot of these other hearings have been televised or Zoomed or whatever. The last one was apparently just an audio feed. But as far as what's happening the next time, I don't know. I mean, I'm still an outsider. I'm still a strange.
You know what?
Strange
if
land.
There's enough public interest in it, and now that your client, Mr. Carney, has been cited in the appellate briefs here as a real journalist, maybe we're looking to change the definition of what a journalist is.
That must drive the haters and trolls just nuts. I mean, the reality is, two jurors interviewed, total of 3 now, right? One of them spoke to NBC, but what we were told, I thought initially, was that jurors would be terrified about, certain individuals harassing them or whatever, but 2 jurors have simply felt this is the right person to talk to. And gave lengthy interviews. That's about as good journalism as you're going to get. I mean, you have a scandal over what happened with the jury and jurors are speaking, which is not surprising. We thought that would happen, especially when all this was denied. And, to get cited in their brief, that's probably going to drive a lot of people nuts and angry. But, facts are facts and whatever. You may not approve of it, but journalism is journalism. And journalists try to get scoops. And these are great scoops.
You can't argue that.
Can't argue that.
There are certain witnesses who feel more comfortable going to someone outside of law enforcement. Right here, we're seeing that in the Long Island serial killer case. Many witnesses are afraid to go to the police because the county in which the Long Island serial killer case, Suffolk County, New York, is being tried has been corrupt for decades. And our DA, our former DA, Tom Spota, is still in federal prison. And so many witnesses are coming out and going to John Ray, who's an attorney who represents the estate of Shannon Gilbert. And that's who they're going to because they feel more comfortable. So listen, however the witnesses want to come out and tell their stories, I say more power to them.
Yeah, and Suffolk County, I mean, it was so bad. You had literally the DA, the chief assistant DA, and the police chief all in the can. I mean, that's insane. I mean, talk about corruption. That is just the worst kind of corruption imaginable. And many people think that they were either covering up these horrible, Gilgo Beach murders, or at least not taking it seriously or avoiding looking into it. And as soon as they got new people in power, they cleaned it up, and they appear to have a pretty solid prosecution of this architect. So, good for them.
Yeah. And that's why when I first started covering Karen Reed and people are screaming like that, this is impossible. No, all these people couldn't cover this stuff up. I'm like, okay, wait a minute. I come from a county where our DA's in jail, the ADA's, everybody's in jail because of police corruption. So yeah, it can happen. It does happen, and it'll happen again. It's not that hard to believe.
Yeah. And, again, we could beat this to death and go round and round, but you can't avert your eyes to the fact that whether the argument is it's too many people to cover this up and this and that, forget all that. I mean, look at the communications and what was happening in the hours after John O'Keefe was dropped off and critically before Karen Reed and what's her name, Kerry and Jennifer McCabe were searching around looking. And why were they communicating in the way they were communicating and deleting and texting when they were all supposedly doing nothing, saw nothing? And why in the days that followed were they getting their stories straight, saying, tell them the guy didn't come in the house, giving updates on where the police were searching, doing all kinds of things, making sure, what are they saying? What are they saying? No more talking on the phone. I need to get a copy of Juliana Nagel's cell phone. I need to do that. I mean, this is all, it's not proof that they committed a homicide, but it's proof that they're acting really weird, really suspicious, and clearly appear to be covering up something, whatever that may be. That's not normal.
But Mark, they were just butt dials. Brian Albert sleeps with his phone in the bed in between me and Nicole. And, it was just butt dials.
Butt dials do. I made a butt dial the other day, actually, and they do happen. But here's the thing. I'm pretty confident that no one anyone listening here in their life has ever seen a situation where a man butt dials on a closed Apple phone and then gets a return butt dial from the recipient who then connects for 22 seconds. And both of these guys look at each other and say, I don't know what's going on. And then these two men just happen to be the same two men who serendipitously tossed their phones on the same day, one day before a preservation letter for those phones came out. That is a coincidence.
Crazy, that coincidence.
That a statistician would tell you is virtually statistically impossible.
And they were also caught playing grab ass at the waterfall the night before and doing their little, their stances that they do.
Also totally normal and not weird at all.
I mean, who doesn't
go hang out in the bar and, get into the fighting position and grab a little ass and hang out and drink a little more and then go home, leave because there's no whiskey and I'm going to go waste it out of my mind, go park some cars at the police precinct. This is all normal behavior.
Oh, yeah, 100%. David Reese, thanks again for the vibe. If the Commonwealth's case is based on Trooper Paul's report, how can they not call him to testify?
It's kind of a problem. They're not going to call him, I don't believe. How can they? The problem is that if they call someone else that has a different position, then, they're going to get clobbered about, are you aware of this guy and have you read his report? And the defense will certainly do as much as they can to establish that they're trying to basically change. So they are going to be somewhat married to this really bizarre theory of somehow hitting your shoulder will break a taillight, not cause any bleeding or bruising or anything, and then somehow your arm is covered in all these cuts for the taillight that shatters into 45 pieces and lands over the course of 30 or 40 feet on the lawn, and somehow the man who was unfortunately hit was hit at such a high rate of speed that he launched himself 30 feet and lost a shoe.
Well, I mean, listen, they could hire an expert, but there is not going to be any expert out there that's going to risk their professional career to back up this ridiculous, laughable theory.
No. And also they're going to
So
have, they can't. And even if they found an expert, you know, we're not talking about from the crackerjack box of the state police like they did the first time. You would have to find someone who at least on their resume measures up to the level of these ARCA guys and then is willing to systemically break down their report and with confidence say, they're wrong, I'm right, and here's why. And the problem the DA will have is you can't just have a situation where the experts have, you know, opinions and it's kind of unclear over who we believe, because that's getting into reasonable doubt. I mean, if you can't knock out KO, no pun intended,
bang,
the
bang.
ARCA, the ARCA people, then you're going to have a problem, because if that's even plausible that it was not caused by a car accident and the injuries are not consistent with the damage to the car, even if you don't find that overwhelmingly scientifically fact, like they seem to be suggesting, even if it's plausible, you're still in the reasonable doubt universe. So
correct. And I may have said in my closing, had I been the lawyer and a lawyer in this, I may have said, if you are sitting back in the jury room trying to come up with alternative theories as to how this injury, how this death to John O'Keefe may have happened, then that is reasonable doubt. You're done.
Yeah.
You're done. I mean,
I thought about this. I think they need to reorganize the closing, but I think also in their defense, the more I thought about it,
defense. In the defense's defense.
They just didn't have enough time.
It wasn't.
So many things. And because the jury doesn't have the chance to get readback, it makes needing more time in the summation that much more important. Yeah. And I'm never one of those people usually who would say, oh, you need 2 hours, then you have a problem. But if you're not going to let them have readback, you're going to rely upon memory and their notes, you know, and if you don't think of something, then there's no reason to look in your notes. You have to have it brought to your attention by the lawyer's closing argument. Then I feel that the defense in hindsight really got cheated by not having the chance to address much more. And I mean, and the, you know, for what an hour's worth was, it was really good, but there was so much more to get out there that they run out of time. And, you know, I think the ARCA was, and some of the things about the taillight were part of that.
What an arbitrary time limit. I mean, I've been, you know, covering other trials lately. I think it was like the Robert Tellis trial. And I don't know, there was something like, I don't know, 6 or 8 days of testimony. And the attorneys were given 90 minutes for closing. Like, listen, where does this arbitrary and capricious 1 hour time limit for a 9-week testimony?
Sorry to go back, you know, you go with what you know. So I go with what I see happen with my own eyes in New York. Trump is a perfect example. So that trial was a couple months. It's actually shorter than the Karen Reed trial. All right. Mm-hmm. But it was a couple months and it was very dense, you know, very whatever. And the lawyers in that case got 4 or 5 hours. Now that's a lot. I get it. Nobody necessarily, that's long. That's
not everybody. Did they use it?
They did, which is probably, you know, ill-advised too. But the point is, there was no controversy there. You know, the judge and the lawyers meet and they say, how long do we need for our summations? The lawyers say, I think we need this. And the judge in that case says, okay. Now I can see some judges saying, no way, where the jury's going to tune out. It's just too long. But in this case, there was no discussion. It was decreed from the bench. You get an hour, period.
Mm-hmm. Right.
And after 3 months in a case where there's no readback, with all this stuff going on, I just really feel that really cheated the defense out of a lot of ability to point out many other things. But That's what it was.
Agreed. I mean, there was so much to tie up. When we were looking last night at, what we could glean at least from from the filings in the appeal, and we noticed that there was a portion of the Higgins day that was sealed. We went back and watched a little bit of his testimony to see if we could try and figure it out in our little super sleuthy way. And just going back and watching Higgins' testimony alone on a short we watched maybe 15 minutes of his testimony. There was so much juice there.
Yeah.
That could have been focused on, but there was so much that they had to cram into that 1 hour that it was virtually impossible and prejudicial, in my opinion.
If you want to know of an example that shows you just how you forget things or conflate things, remember that one juror affidavit who said we were intimidated by Brian Higgins being there? It wasn't even Higgins. It was the wrong Brian. And I mean, how do you make that mistake unless you're just conflating over the course of time, it all melds together. I mean, that's
all the Brians blended together. There was like five Brians in this trial.
Yeah.
It was crazy. Will we ever know what issue got the feds involved? Reed Birchmore DA. Thanks, Jen.
Ever? Yeah, I would think so. I mean, some people think that Birchmore kind of evolved out of Reed. Some people think the other way. Some people think it's just a general DA thing that they stumbled on all of this. Truth is, we don't know.
Yeah, we don't. Will we ever? I don't know. Maybe. Amy, thanks. What are the chances of this appeal being heard before the next trial date? Does the trial get put out further now?
It better, because it would be a shame if we retried someone who was later found to have already been acquitted. So the answer to this is 1,000%. This issue in the SJC has to be resolved before a retrial, 100%.
And if that means that they're all jammed up in the appellate court and they can't hear it and it takes time, the trial date's going to have to get pushed out, right?
Yeah, I mean, the judge set the January date way back when, assuming this is going to play itself out. And it really depends on how long it takes. I mean, the other thing is, what if the judge hearing this decides, I'm going to send this to the full court? That's going to add time. And then what if they send it to the full court and then the decision is we're going to send it back to Cannoni and order a hearing? That's going to take more time, after which she has to do a hearing and issue a decision, which somebody may want to appeal. That's going to take more time. I mean, this theoretically could go on months and months, or it could wrap itself up in the next, 4 to 6 weeks, whatever it is, and the trial schedule stays on point. But I think realistically, there's a chance that that schedule that was set by the judge doesn't hold, through nobody's fault. It's just the way these things happen.
I mean, she fully expected the appeal, no matter which way she ruled, and she said that. Like, I'm setting a trial date for late January because I'm expecting an appeal. So
yeah, no one is letting a trial level judge determine, a double jeopardy claim on a murder case. I mean, clearly, I still think the DA really probably could have made all of this moot by just saying, we get it. Murder is weak. There are ways to streamline the case. We actually now, one would think, would feel more optimistic about the count 2, which has nothing to do with intent, does have a higher focus on alcohol and those sort of things, and really streamline the case towards that. But, here we are, they're dug in, and, some of it's, I think, is just ego and public perception. They're just dug in, and I just can't fathom that even if they win, that they would retry her for murder. And here we are back to Aruba and text messages. I just can't believe that they would do that. And because they know the jury acquitted her. Forget the law. They know factually, whether they believe the jurors were too stupid to publish it. If that's what they think, I don't know. But they know that they didn't want to get her on the murder case. But they keep coming, and here's another bingo. That's like very zombie-like. You can't embarrass them. They just keep coming, and they don't necessarily value their credibility. And I would be terrified if I were the DA that has to retry this case, if they retried her for murder, assuming they had the right to do it, to literally look at jury selection and say, we're here and the charges are murder. And I would be terrified the night before saying, what do I do when some juror says, "Excuse me, I thought she was acquitted on that count. Why are we here?" And how you or the judge is supposed to answer that. I don't know why they would even invite this possibility.
Well, that's why I don't think they'll ever drop the charges, because there's just too much ego involved here. I don't think they'll willfully just drop the charges, as they should, but I don't
Yeah.
think they will. Oh, thanks, David. They didn't give a time limit and tell us. Okay, I must be thinking of Ashley Benefield. Maybe they gave the attorneys in Ashley Benefield 90 minutes. Oh, speaking of a different trial, the Boulder, Colorado trial that I'm handling, or that we're covering right now, for the supermarket shooter at King Supers who killed 10 people in March of 2021. We're also watching that trial now. And Michael Daugherty is the DA for Boulder County. And then it turns out that you have a connection to him.
Yeah. First thing, this is so crazy about society these days that I don't even remember a mass shooting in Boulder that's only 3 years ago is disturbing, because there are so many other ones that honestly, I don't even remember that. I'm sure I knew back then, but Mike Daugherty was, I think, 1 year before me. Yeah. In the Manhattan DA's office. We overlapped. He was there the entire time I was. And then he must have left in, I don't know, 10 or 11, moved out there. I'm pretty sure he's married to a classmate of mine from the DA's office. And then, several years ago, he became the elected DA in Boulder. His first assistant was another colleague of ours from the Manhattan DA's office for a while. And he's doing really well out there. And I know that because I get all like the campaign emails and requests for money.
Donations.
All of that. But no, he's highly respected guy in the DA's office. My understanding is he's highly respected by law enforcement and the citizens out there. I had no idea that he was personally trying a case. I couldn't even tell you what his trial skills are, other than to say
I can.
very sincere, very likable, very earnest. And if someone chooses to be a career prosecutor, you want somebody with his ethical, moral, and intelligence to do that. So I would assume that everyone is pleased with what he's doing.
We have coined him DA Daddy. And it wasn't even until after a couple of days of trial that I did the deep dive into him. And then somebody said, "Oh, he was a Manhattan prosecutor. I wonder if he knows Mark." Mm-hmm. It was, and we have a crappy like WebEx feed. There's no cameras in the courtroom in Boulder, so it's crappy WebEx. We can't really see him. He gave I overuse this term, but a masterclass opening. We couldn't even really see him. And so it became more like an audiobook. He's like got an audiobook voice. He painted a picture that we could vividly see every single thing that happened in that supermarket that day when this SOB went over there with his couple of weapons. He was 21 years old and gunned down 10 people. It was one of, if not the best opening statement that I've ever heard. And I when you have the time to listen to it on the subway or something,
that's great.
Listen to it, because it was unbelievable. And we were saying to each other, this is the guy that should be training Adam Lally. Like, how do you get a prosecutor like Michael Daugherty in a case like this in Boulder, which is an amazing, beautiful place to live, because I lived there for so many years, I know. And then you have like a guy like Adam Lally in Massachusetts, who's literally putting people to sleep and getting handheld and coddled by his mommy on the bench, who's like, "Do you want to object, Mr. Lally?" Like, it is night and day.
Well, at the risk of,
if you talk to him, tell him he's our new DA Daddy, and we can't stop loving on him. Okay. It's fabulous.
I mean, at the risk of being too obnoxious or whatnot, we come from the Manhattan DA's office, where the recruiting is a little, all due respect, it's a little more competitive, I think, than the Norfolk County, Massachusetts DA's office. Everyone from all over the country wants to go to, the law and order office, if you will. And the training system there is very sophisticated, you're also in the heart of New York City, and they bring in all this very prominent and skilled alumni to help train young prosecutors and tell them about the values and this and that. So, I mean, by its nature, you're going to get, really good lawyers, and none of this is surprising. I mean, everybody likes Michael, and, no one is surprised at how successful and respected he is. I had no idea he was that level of trial lawyer, to be honest with you. So
wow, he's so gentle. It is like the complete
he's
opposite.
calm. Yeah, yeah.
You know, he's very kind, and you know, he's examining
Very
all of these witnesses who, like, you know, experienced the worst trauma of their lives, watching their friends and loved ones being gunned down. You know, these people that worked in the Boulder King Supers had worked there for 40 years. Like, people never leave. They hire people, and they know everyone in the neighborhood. And it was just so, the way he brought that out, he spoke about each victim in his opening and what they were doing at the time. It was magical, really.
That's not surprising, because again, the
Yeah.
words I use is that he's very earnest. You know, he
Yeah.
comes off as really sincere in everything he does and talks about. And I'm not surprised that it would translate to speaking to a jury about just hell on earth, like this thing that you're describing. So it makes perfect sense to me.
He's really great. I'll donate to his campaign. Cookie Harris, thanks for the 20. Just finished first draft of an appellate brief I've been working on. After this case, I can't imagine trying to tackle the basic foundational laws which govern our nation within Massachusetts courts. Hats off to you, Mark.
Thank you.
To you. Thank you, Thomas. Grifted $1 million Mark memberships. Thank you, Thomas. Anonymous, and Lisa Hawkins. Thank you so very much. Well, Mark, I've kept you here long enough, and you got to get back to your own brief writing. So if there's anything here you would like to say in closing, or comments, or thoughts.
You know, I thought the papers they filed were really good. I mean, that's not surprising. I thought the papers they filed in the lower court were really good, but I actually feel like these papers are tighter and better, in the sense that in arguing some of the points that the DA obviously carried a lot of weight with the lower court about the defense, you know, consenting to the mistrial. I thought they handled it very, very well in this. And I also like the approach where they talk about you've got to use common sense and do the right thing. And I hate to say it, bingo, but substance over form. And we're talking about an acquittal here. We're not talking about widgets. You know, this matters, and there's no precedent, and there's a time and a place where the law evolves. And this will be interesting, because to deny this when everybody knows that the jurors acquitted her, and just deny it on the basis that, well, it wasn't published, without even saying why that happened, I think really undercuts the public's confidence in how the courts function and the transparency. And if nothing else, even if this is very much going to be denied, lay it all out there, make a factual record, and somebody write a decision that accounts for all of that information, and then say, but here's why you lose. Just do it clearly and transparently, not, you know, well, that's been the law of the land of England since the Magna Carta, that nobody literally said not guilty, so beat it. I mean, that's just not, in this unique circumstance, how I think this ought to be done. We'll see.
Is John Adams on the bingo card? Because that was mentioned. John Adams is often mentioned in Massachusetts as being
facts are stubborn things. That is him. That's from the Boston Massacre trial. You know, that a very unpopular position to take back then. But John Adams is, you know, the quintessential defense attorney. So
this is very funny. This is a very funny comment, which I'm not going to read out loud, but it is very funny. All right. I can't. It's just going to start too much. I can't get into politics in this chat, because this is crazy. Thank you for coming on with me. Do you have any appearances tonight? Is there any place that everyone can find you tonight?
Yeah, we're gonna do the Young Jerks thing at 6:30. I think they want to talk about the recent briefing and recent events and whatnot. So yeah, for there, 6:30.
All right, good. Well, everyone should come here first and listen to me read the whole brief, so that they know what they're going into when they come see you at 6:30 over on Young Jerks. So, you know, we can double dip here. Thank you guys so very much. Thanks, Mark, for coming in.
Thanks. I'm going to go back to earnings so I can pay my mortgage.
Go back, you grifter.
Thank you.
Soon.
Take care.
Thanks.
Bye.
Oh, wasn't that fun, you guys? See, we're always good for a surprise guest or two or three. 6:30. Be there. Be square. Do you guys want me to redirect you? It's only 3:00 now. You might just have two by the end of the day, Carol. So nice. So nice. Do we have any pressing questions before we wrap? Any thoughts, concerns, anything on your mind before we go? It's been just about 3 hours. Love that guy. Isn't he great? Amazing. Amazing. You guys are amazing. Share the stream, like it, love it, smash the like button. We promise you that Canton PD will not get a hold of your DNA, and neither will. Oh, the glare just started. Okay, wait, let me redirect. Hold on, Nanny Goat. I'm going to redirect. But for those of you who do not know Will, I forewarn that he does not have the clean mouth that I do. So if you are going to go over there, I'm going to redirect you because that's the kind of friend that I am. Just, guide your actions accordingly with regard to, the language. If you don't like the language, I'm just going to warn you in advance. Not that there's anything wrong with that, because there's not. But I'll redirect you over there because that's the kind of girl I am. Just make sure you tell him Cupcake Invasion and that I sent you so I get credit. Okay. Thank you, my friends. As I always say, my moderators are the best on YouTube. They rock. They are so amazing. And thank you guys for being here, my moderators, for, being here. As always, love you with all of my heart. Cupcakes, thank you so much. Emily Baker has like 10,000 people watching her on that jumper trial. I don't know. Is that jumper trial over? I thought it was over. Well, good for Emily. Good for Emily. It's not a competition. As I say, yeah, well, you want to go what I'm trying to do, Danielle, on the Boulder trial is I'm trying to parse down the witnesses so that we can watch the ones that I feel are most important, because I think that the really most important stuff that we want to trial Frankie's mom out of that trial, the stuff we want to cover live is going to be like the expert testimony and his family's testimony, the shooters. So I'm trying right now in my way to get down to some of the most percipient witnesses from the past couple of days so that we can kind of catch up on that trial in real time. All right. So make sure you have all of the notifications set. And then I may have some time today to do that. I'm not quite sure yet because I'm waiting for somebody to come to fix something at my house, and who knows when they're going to show up. So it kind of like puts me in a way that I can't really plan, but thank you. And hit the like button. And as always, my friends, be cool, be kind, be classy. It's not hard. I love you, cupcakes. Peace. Go to the glare. Tell them I sent you. Cupcake Invasion. See you guys real soon.